Hello, everybody. Welcome to ProLaLa at SPLASH' 2024. I'm James Gwimelman. I'm one of the PC chairs, along with Srutarsi Basu and Emma Tosh, who are joining us remotely today. I'm really pleased to welcome everybody here in person and online. I'd like to give thanks also to Vasu, our student volunteer, and Sean, who is working AV. And we are going to kick off our program now with a conversation with Matthew Butterick. There's Matthew. So Matthew is debugging the
Thank you.
microphone.
All right, go ahead.
Yeah, Matthew is a lawyer, a programming language coder, and a typographer, among many other things. And so we thought he'd be a great example of somebody who is bridging the law and PL communities. So let's just get into it.
In unhealthy ways. So maybe this is a cautionary tale, but thank you for having me, James. Thank you, esteemed guests online and elsewhere. Pleasure to be here.
So you have had a career that spans both law and technology. Can you talk a little bit about how you ended up in this weird space connecting the two that have brought people to this room?
I ended up in this weird space probably the same way a lot of you ended up, which is that I'm a weird person, and I just can't help pursuing every silly idea that pops into my head. So my interest in both design and the visual arts is ancient with me, as is my interest in technology and programming. So I think very much that my preoccupations here in my middle age are exactly the same as they were when I was 11 and 12 years old. So there you go. I just can't help myself. So over time, though, I've just tried to find more ways of blending the two. There you have it. So we'll see where that goes.
So you said you had this fascination with visual design. How did that bring you into programming languages?
Well, my main interest in visual design has always been type design and typography, which if you're thinking of pursuing this as a career, don't. The one big problem is that the complexity of doing type design, the observable complexity, is much less than the actual complexity. People see a font on the page and they say, what, it's just letters, how hard could it be? But in fact, it is very hard to do everything in a font. So as I got more, my first actual job out of college, if you can believe it, was doing type design professionally. And within a year or so, it was, even though I'd kind of dabbled in programming, it suddenly became clear that to actually get to the next level of certain types of work I wanted to do as a type designer, I needed to do software assistance. Actually, here's a fun fact for all of you. Anybody know about this programming language Python? Have you used it? Do you know who invented it, right? Mr. Guido van Rossum, right? Well, Guido van Rossum's brother is named Joost van Rossum, and Joost van Rossum is a type designer. So Python, in part, I won't say was invented to do type design, but Joost and his partner, Eric van Blokland, were using Python to automate type design way back in 93, 94. That's when I first heard about Python. That's how I heard about it. I saw them and they were showing me this new programming language, and I said, what's it called? And he said, Python. My brother invented it. So that was so there's been a very long history of software automation in typography. And in fact, this goes back far beyond me. You can look at the early computing systems that were developed. One of the first things that people made on every system that's ever existed is a typesetting package. Even the gentleman who invented the C language, right, Mr. Kernahan, is that his name, was the author of the TROF software, right? He's a typography fan too. So there's so many wonderful software. Obviously we're all familiar with tech and LaTeX, but there's many document automation packages that have been invented over time. So it's just this kind of ongoing subject of nerdy fascination. Anyways, long story is, it is, if you get into type design, there's plenty of software work to be done if you like to.
And so then once you were into programming languages as a way to support the type design,
yes,
you wound up doing a lot of work with Racket. How did that come about?
Well, the Racket, my work with Racket kind of originates, I have this online website called Practical Typography, right, which is a, typography helping website. So when I first started doing that, though, I said, the only way I want to do this is if I can make it the most typographically groovy site on the entire internet. And I realized that to do that, I couldn't just sort of sit there cobbling together HTML by hand or even doing it with JavaScript. I needed to basically invent my own system for doing it. So what led me to Racket was as I started to investigate more about how to programmatically manipulate HTML as a data structure, I kind of learned about this kinship between S expressions and things like XML, right? This idea of tags and attributes, they all kind of fit together. So that's kind of what led me to the door of Racket. The folks who made Racket have a really neat document language called Scribble, which is basically the text-based version of Racket. So I said, wow, they already kind of figured out how to do all this document manipulation. So I sort of took that Scribble tool and started to build on top of it to make what is now an open source web publishing tool called Pollen, which I've maintained for 10 years now. But this Pollen system is at the core of every single thing I do online. So even though it took a long time, it really has paid dividends, because I honestly feel I can do things with web pages that other people simply can't, unless they also use Pollen. So that's kind of what got me into the Racket world, was this desire to see something. And I mean, I think this is an interesting thing because, all these folks talking about, programming languages and especially domain-specific languages. I went the opposite way. I wasn't interested in domain-specific languages and then thought about where could I use this. I really had this problem in my head that I was struggling with how to solve it. And I suddenly realized, like, what I should do is make a domain-specific programming language. So again, these kinds of commitments, then you spend 2 or 3 years in your home office buried in reading, but it's worked so far.
I mean, comparing that with the story of how Knuth invented tech makes me wonder if everybody with a different programming language paradigm ultimately converges on a typesetting language that is optimized to that paradigm.
That may be so. Didn't Knuth have to take 10 years off to do that system? So I feel like what's that book, The Metamorphosis, right? You wake up in the morning and you find yourself someone who's preoccupied with domain-specific languages, and then years pass. So we'll see if I ever fully get back to it. So
the other part of your story is you're now a lawyer. So how did you go from being a type designer who's making his own programming language to do it to being a lawyer? What made you go to law school? Yeah,
I mean, I can only attribute more of my, weird curiosity and my refusal to just keep taking no for an answer. As I mentioned a second ago, when I graduated from college, I went right into type design, and I ended up migrating into the web world, of the 90s in San Francisco and so on. And at a certain point, ended up with what at age 28 seemed like a cool little pile of cash. And I said, well, if I ever wanted to do something else intellectual, this is probably the time to do it. And I considered going back to school to get a grad degree in computer science. I also considered accounting for some reason. But then I ended up thinking that law was probably the most interesting and flexible. So I did that. But of course, after law school, I didn't end up. I practiced for a couple years, but it wasn't before too long until people started, being interested in typography. I published a website called Typography for Lawyers, which, again, I didn't expect it to go anywhere, but it turned out that there were a lot of nerdy lawyers across the country who were also interested in it. So, I wish I could say that there was some master plan, but mostly I keep doing these nerdy, weird things. And most of the time they fail, but sometimes they catch on, and at that point I just kind of follow along behind and see what happens.
That's what I tell my students when I recommend Typography for Lawyers to them, is that this is a really good book on typography that also happens to answer the questions that lawyers in particular have, like how do you type the section symbol? And how do you put that into your documents so that it comes out the right way?
I want to point out another thing about typography for lawyers that nobody notices, but hopefully you all will. There was very much a kind of software mentality in the book of trying to, because I've certainly seen plenty of typography books that I feel, I won't say fail, but they make the reader struggle in that they kind of throw you immediately into the deep end and talking about the golden ratio and things. And I'm like, that doesn't really help. So I really tried to say, like, imagine if this were a math textbook or something, or a programming one. You want to work from simpler concepts up to more complicated ones. So finding a way to sort of sort the information in a way that somebody who was completely new to this material, right, would start to be able to do things and say, I see the value, I see how to do this. That was really important too. That was really important too in that, the beautiful Racket website I have, which is about how to develop domain-specific languages. I mean, just kind of trying to figure out how to, I'm sure all of you have to do this because many of you do classes for students. Kind of putting things on this nice smooth ramp. It's it's an interesting challenge in itself.
So let's get into some of the ways that law and CS, and especially programming languages, are like each other and are different. So how different is the headspace you get into when you're working on a legal project versus a technical one?
That's an interesting question. I would say certainly that my technological know-how surfaces in my legal work. Of course, I try to automate as much of my legal work as possible. Other lawyers still remain unconvinced this is a good way to do things, but it's headspace. Do you mean elaborate a little bit?
Okay, so I've definitely written code and written prose for other people to read that's supposed to be legal and precise. And there's somewhat different mental places I have to go to in order to do these two things. Certainly the design work for a technical project requires a kind of concentration, but a lot of the line level work I can do in a way that academic writing would be hard. I can do it with less of my brain turned on or a different part of it. So when I'm too agitated to do one thing, I can do the other.
Yeah, I see what you mean. I mean, programming for me is satisfying in a way that is sort of seductive yet also dangerous in that, right? I mean, everything in programming eventually arises from the capabilities and also limitations of the underlying machine. And, so to kind of, so the satisfying part of that is if you're, once you get into the groove of how the machine thinks, you can really get a lot done. What is impairing about it, however, is that that's not really how most things in the world work. And when you're writing a legal brief or something, right, you're having to convince another human being, right, which is sort of a more tangled and messy project in any sense. So sometimes I wonder if that's how we could bring more of that into programming. I mean, programming, I think sometimes when we are using programming languages, it seduces us into forgetting how much isn't there. I mean, when we were talking about this event a few months ago, I said one of the great comedies of programming languages is how bad they are just representing numbers, right? Most programming languages can't represent rational numbers. Racket can. Most programming languages do violence to floating point numbers. Most don't have any sense of infinite numbers behind plus I and f dot 0. So there's so much that is not being represented. So I would say that law's orientation around actual facts in the world is very different, right? And but I think also worth understanding how to grapple with. Programming languages, right? It's always about abstracting away. I always like that phrase, leaky abstraction, right? It's funny because every abstraction is leaky. That's why they call it an abstraction, right? There's stuff that you're excluding, that you're not representing. So to the extent that stuff's being cut out, you're losing information. But at the same time, even though when I engaged with legal writing, there's still a process of you do have to surface what's important, but again, you have to ground it in the actual facts.
So getting into that, how does programming languages represent concepts? And how is that different from how legal language or lawyers represent concepts? Because there are ways in which lawyers and programmers are very much both people who work with words to do stuff. But there's a sense in which a concept or a variable or an assignment in a programming language is very different from what it does from when a lawyer talks about consideration or the reasonable person.
Yeah, and I want to be careful here because this is part of your topic for the whole day, right? And I don't want to say something that's going to impair anybody's enjoyment of your conference. I mean, this idea of, I mean, yeah, you're right. Like, we read certain laws, and if you have a programming frame of mind, you can say, wait a minute, this is something that would have been better expressed in software. At the same time, like, not everything is like that. I think it is, as we think about comparing programming and law, I think it's good to list all the things that you think are bugs and features, and then just kind of invert what you think about it. Because, for instance, I think maybe somebody who loves to do programming and PL theory would think that the way things are described in the law is messy and imprecise. And at times it is. But there are also reasons for that, right? And, whatever, if you want to call them social reasons, political reasons, reasons that allow the law to defer as many questions as long as possible. So maybe these are, maybe there's something to be learned there.
A friend of mine has a joke about a computer scientist who's thinking about going to law school. So his friend is in law school. Let's sit in on a class. So he goes to a class, and the professor is explaining a case, and he spends 90 minutes walking through every line of this and just bringing out how precise and perfect the reasoning is, and really illustrating how one thing follows from the next. And the programmer's like, this is perfect. I love this. Like, this is exactly the same kind of logical reasoning that I like. And he comes back the next day to sit on the next class, just make sure of it. The professor has them read the same case, and he spends the 90 minutes tearing it apart, showing how every line contains a fallacy, and that the entire thing is badly reasoned and will lead to terrible results. And goes up to Professor afterwards and asks, wait a minute, which is it? I just wanted to see both sides. And that there's something in that about the way in which lawyers can be comfortable with ambiguity and with there are reasons for and reasons against, and we don't always reach a definite conclusion.
Yeah, I think there's something to that. Another thing that I think about is, whether part of our social agreement to be bound by the rule of law is in part premised on the fact that the law is written in our language, and that anybody in principle can step up and try to make sense of it. And maybe if we required all of the laws to be written in OCaml or whatever, that wouldn't be the case. That would feel more exclusionary. Though we could make another, we could talk about, your average math proof. I mean, there's an argument like, why are you writing it in, English and symbols? You should write everything in like strict formal logic. That's the only, but we don't do that either, right? Because there's this trade-off between wanting to make the reasoning accessible and observable. So I think that is part of what the law accomplishes. Again, lots of mistakes happen in the law, whether they're intentional or unintentional or just failures to reason through things in advance. But yes, I agree with you.
So what do you think would go wrong if we tried to take the entire United States code and just transform it into one large declarative program?
Is that your secret project here at ProLaLa? You're going to propose the...
No, actually. I kind of think that's a crazy idea. There are parts of it that might work for, but I have my own thoughts on why it would fail. I want to hear whether you think this would be a good idea.
Why you think, if we just turned the entire U.S. code into a software program?
Yeah.
Oh, I think it would fall apart very quickly because, you all may feel differently, but at this point in my programming career, I feel that data representation, is the thing. It's where everything starts. It's not, algorithms, it's not program flow. It's like you have to have your data structures correct before anything else happens. So, in law, you are confronted with that question right off the bat. How do we represent, these things? And I think it's very hard to do that in the language for the reason I said before, right? Every abstraction is leaky. So, judges and juries struggle with the definitions of terms. They're leaky abstractions even in the English language. That problem is only going to become harder if you represent it in programming. Unless you also invent like an entirely new way of programming, which maybe should be the first step.
I mean, so one possibility here is that law is messy because the world is messy, and we have to use existing concepts, and then they don't always map onto things in the world. So when you talk about the right to bear arms in the 1800s, what weapons have changed dramatically. in the 107 years since that. If we make a statement about species or about different kinds of animals, then you get the California Supreme Court ruling that for purposes of this regulation, bees are fish. And it sounds absurd on the face of it, but every step of the reasoning to get there has some logic behind it, because this species is like that species for purposes of habitat protection. And like, we're trying to deal with a world in which animals and firearms and other things don't come neatly pre-sliced into existing taxonomies. So part of it's just trying to map our concepts onto the world.
Right, it's difficult, and another aspect of it is that embedded in the law are a set of kind of these threads of, what would we call them, like historiographic or policy decisions. Like, we could talk about how the federal income tax code maybe should just be one giant program, and the IRS forms, which I consider like some of the most beautiful graphic design in the world, in the way that they explain the law in a visual and graphic manner. Maybe that should actually be the replacement. But as my federal income tax professor would have said, he's like, there's so much more happening in the tax code. It represents like basically what was important to our country at every point in terms of what kinds of behaviors they were trying to incentivize. My wife is a appellate lawyer who works for the California government, and she does a lot of legislative history research, right? Which is like something you don't have in code, right? To understand the code, I guess sometimes we do go to the Git history and say, what were they thinking? But in California law, it's a very important part of interpreting laws, is to go back and say, what did the elected representatives think at the time that they were drafting it? And maybe they didn't get it completely right, but we can at least go back and try to reanimate in a better way what they were going after.
So we've been talking a bit about parts of law that don't naturally map onto things computer scientists do. What do you think is the hardest part about computer science for lawyers to appreciate? Like, what do programmers understand in their bones that lawyers don't necessarily appreciate?
What programmers understand in their bones is that like laziness is such a good urge, right? And it motivates you. I think what the most amazing thing about, now that I'm I didn't practice as a lawyer. Like I mentioned before, I got out of law school, practiced for a couple years, and then stopped for a long time, and got reactivated a couple years ago to get involved in some of these litigation. So it's funny to me because I'm suddenly working on these cases that have dozens and dozens of lawyers, and these are very busy, well-trained people, but the amount of, I don't think I'm giving away any state secrets, the amount of actual automation, right, that is part of the average lawyer's workday is very small. Right? So, and as a programmer, I just think like, oh my gosh, we could write this, all these discovery requests or responses in a racket program that's 20 lines long. And in fact, I do write small programs to generate some of my more complicated documents. But I would say that's a big one. I know it seems kind of prosaic, but it's more than just an operations or productivity thing. Again, it's a way of thinking about how you do your work. To get back to that earlier anecdote I said about inventing practical typography and the pollen system, right? The shift in my thinking was going from thinking of HTML as a place to do work, right, as a language unto itself, which it is, but it's a terrible language to use. Thinking of it more as the output of a better, smarter system. So as a lawyer, I think about this too. Like any document I make, I'm like, wait a minute, I'm making this document. I should think of this as the output of a better, more generalized system. But it's surprisingly sparse. I think I've heard every now and then over the last 15 years, I get an email from a lawyer who said, I'm starting a new practice and I don't want to use Microsoft Word. I want to use LaTeX. And I say, let me know how that works out. I mean, it's going to be good for you, but the day that you have to send something to another lawyer or a judge's chambers, you're going to have a copy of Microsoft Word.
So we're going to hear more about this later today in Charles Duan's tutorial, but I do actually write the majority of my articles now in LaTeX using Charles's Blue Book citation package. And it's exactly right. The pain point comes when we have to leave that self-contained world and provide Word files for the law reviews to edit. And the export, or rather the import capabilities of Word have gotten good enough that if I produce a PDF from LaTeX and then import it using Word, it comes out approximately right. There's just a lot of small formatting changes that have to happen. But the thing is, the law review editing process is so inefficient and so much a process of transitioning some Word file into the journal's specific Word format that most of the time that extra work just gets eaten up in the work the journal would have done anyway.
There you go. I mean, I think it's. I actually have. Here, I'll out-nerd you a little more. I can't bear to use LaTeX, but I thought, you know what I'll do? I'll make a better version of LaTeX for my own use. So I have a document processor called Quad that I wrote in Racket, and it takes my markup files and it lays them out and it compiles them into PDF. Boom, all in one place. It works beautifully. I don't know what to do with it, and I don't know who to share it with, because this whole mode of working, right? The attorneys that I work with now, it's like they don't. I actually sometimes wonder if I'm just a little bit before my time, and I'm interested in your view because you have younger students. I kind of wonder if it's generational that I'm like Gen X, right? So people of my age, they learned to about document preparation. In my case, on a typewriter, or at worst on like a personal computer, right? But I don't know, maybe are younger people thinking more in terms of markdown, right? In terms of like, hey, I'm doing something in a markup language that doesn't necessarily literally correspond, right? This whole WYSIWYG thing, that's a very much an 80s artifact. And I sometimes wonder if maybe if I just wait 10 or 15 years, once these young people become experienced lawyers, they're gonna be like, give me a better document processor. What do you think?
I think that young people in computer science absolutely think this way, and absolutely use a variety of markup languages or structured file formats. So TOML or YAML or something using a JSON or anything that has some structure. And they're very comfortable weaving among multiple files and formats. And I mean, maybe the problem is that there's, as with any standard, there are so many to choose from, but it's absolutely part of the intellectual toolkit. This has not penetrated at all to law students.
Well, what can we do to fix that?
Send more technically savvy people to law school.
Why do you think that resistance is, though? I mean, it just seems like lawyers would love this. I mean, you as a legal academic, are using these tools in your own work. Obviously, you're a little, special in that regard, as far as being technically adept. But why aren't people lazy enough and to want to learn these tools?
So I think that they're really like two broad tribes of lawyers, which are the people who really like the logical part of it and the people who really like the arguing part of it. So there are some people who really love the abstractions of law and understanding how things fit together. Some of these people are really happy as tax lawyers. Some of them work on deals. And then there are people who really love words. And they may have been happiest in their history or political science or English classes and are glad they never need to take math or programming again. And they see things in terms of words and their meanings and how to string them together. And the idea of a program to abstract it is somehow cutting them off from the thing that they really like about law. It's like, I didn't go to law school to do this.
Yeah, that's a good point, and I think it also loops back to your question about distinctions between programming and the law. Once we, in programming, once we decide on a data structure, I mean, I mentioned before, it's an abstraction. Things are left out that maybe should be better left in. But there's also an implication there. There's an assertion that this is somehow the ground truth, and that's just not how it works in law. Like when people say, oh, facts are objective. No, they're not. They're not objective. I mean, that's why we have juries, is that facts are often in dispute, and somebody has to decide what the facts really are, and it's a matter of presenting evidence. We never have to do that when we're writing a program, right? We never have to sit in front of OCaml or Racket and bring evidence to convince the programming language to give us the data structure we want. Maybe we'd be better off if we did. But it's an interesting kind of there's more. I don't know. Maybe there's something to be said for putting that kind of freight on the person who wants to assert a certain view of the truth.
I mean, I teach intellectual property, and when I get to copyright and infringement, and I have to start showing my students examples of what's similar enough to infringe and what isn't, they invariably ask me, okay, what's the test? and I recite back to them, it's substantial similarity, whether the defendant has copied a material amount of protected expression. Like, what does that mean? Well, here are some examples. Let me show you. Is there a rule? You learn it only by seeing what judges and juries have decided is too similar and sufficiently dissimilar that it's okay.
Yes, exactly. So yeah, it is a lot more wobbly. And in fact, I use this. I use this example in my typography book because I talk to lawyers sometimes think that all this typography stuff is just about looking pretty, and they don't quite believe that there's something substantive about it. But I make this point, like, just imagine a jury trial, right? When you're presenting evidence, part of how you, and in fact, juries are instructed, right, when a witness is on the stand, that you can judge the credibility of their testimony, right? You can judge the facts coming out of their mouth that they're testifying to based on their demeanor or how they present themselves, right? I mean, juries are specifically instructed to use presentation, right, as a means of weighting their substantive understanding. So I feel like a corresponding thing happens on the written page.
I'm at the point where I cannot even work in formats that don't have some structure and produce decent-looking outputs. There are plenty of people I collaborate with who are totally comfortable just having a Google Doc that has 40, 50 pages of notes from our meetings and random thoughts and fragments scattered, and they can jump back and forth. And I certainly have lots of unstructured text and clippings saved on my computer, but the actual document I'm working on, it always needs to be in a state where it compiles to something that looks good.
Yeah, that's a good tip. I mean, the sort of underlayer of all my typography discourse is also that there is a kind of stealth programming component, right? I mean, honestly, there are a lot of people in the world, not just lawyers, who don't know that, what a hard page break character is and what it does. It's like, that's a form of control of your document, of programming your document. That's just so basic, right? If you're a programmer, but it's new to a lot of people who came from a different direction. So learning that they can control their document that reach that first level. I don't know. So I sometimes wonder, right? It's like, if I show people that there's ways that they can control their document that will save them time for the rest of their life, should that make them more interested in these tools? I don't know. I'm not sure I'm making much headway, but I make the argument anyhow.
Are there places where you think that are really promising for overlap between lawyers and programmers? Places where they think the same way, that we could really tap into that synergy?
Oh my gosh, synergy between what are you hoping for?
I mean, you've talked already about the idea of convincing lawyers to automate, that programming and tools that let you move up a level of abstraction could actually let you cut out a lot of the busy work and do the things that are interesting and important. So that's one of them, is the legal tool chain that lawyers use to produce their work product. Are there other places where there's some kind of connection that one could really learn from the other?
Yeah, I think of it more, frankly, I think programming could learn more from the law. I kind of wish, after decades and decades of programming, that there were more different kinds of programming in the sense of, messier forms, probabilistic forms. I mean, I guess, some of you know about my work with these, AI cases, but I actually think AI is interesting technology in that it does represent a different way of modeling information and producing a result. I won't call it an answer because that implies it has a truth value. But again, to kind of go back to something I was saying at the top, pretty much our entire culture of programming, 60 years into whatever kind of modern computer programming, is all based around machine architecture, and it is very strictly focused on that. I think it's actually no coincidence that, to me, I perceive in the last few years there's kind of a growing interest in what I think of as low-level languages like Rust or Zig, or even Swift to some degree, right? Compiled languages, typed language, things that really go hard and close to the metal. People are kind of rediscovering this, which I think is great, right? But at the same time, I also sort of wonder, I don't know, what's out there. Have you ever used a quantum computer, by the way?
I have never used one, but I wrote my undergraduate thesis on quantum computation.
Okay, so you like that just represents a different way of doing computation, right?
Yeah, and the idea of the thesis was, hey, like, we don't have any of these devices yet, but when we do, the rest of computer science is ready to make use of them. And
Yeah. Oh, I'm sorry. Go ahead.
yeah, it's kind of unfortunate that we really have not figured out any more uses for them in the 2 decades since then. It was factoring numbers more effectively and speeding up database search a little bit. And those are still the only 2 algorithms of interest in the entire field.
And you also need a quantum computer to do it. Like, I've not done any programming on the machine learning side, but I have done a little bit of sort of good old fashioned AI programming with Racket. I did a whole package for doing constraint solving problems. You know about those, right?
Yeah.
A little bit. But I mean, I just think that's just a really interesting way to tackle a problem is to program a solution by not really programming it, right? What you're doing is you're describing kind of the problem space and you're letting the computer search that solution space in different ways. And it's fun because, it's like math is real, probability is real, and, you can, hill climbing algorithms work if you drop enough random searchers around the search space. It's just really neat how it actually doesn't fail every time. So, but again, these kinds of techniques, I was working on that because I wanted to, if you can believe it, I was trying to figure out a way to lay out footnotes in Quad. And I thought, this is what I need, a constraint solver. And unfortunately, it does work for that purpose. So I'm not sure what the lesson here is. I just keep learning that these things do work, but it kind of takes me farther into the rabbit hole. But lest you ask, yes, I am aware that the optimal paragraph line breaking algorithm in LaTeX, I know all about it. I did implement it in Quad, so I've got that too. Don't worry. Also, the hyphenation algorithm in LaTeX is very beautiful and interesting. I've implemented that one too.
And yet, the page breaking and page arrangement in LaTeX is so bad.
I think famously, that's not an optimized algorithm, right?
Yeah. Anyways, going back to something you mentioned briefly, you have reactivated your law license and gotten back into that game because of the AI litigation. So you've been counsel on lawsuits against generative AI companies for training on authors, artists, and programmers' work without their permission. As a lawyer and programmer, how are you thinking about generative AI and about human and computer creativity?
Well, that's kind of where it all starts. I mean, some people like these cases, some people don't, and I welcome all the views. I mean, I've heard from everybody, and I understand it's a controversial topic. I mean, for me though, it began very personally a couple years ago when this GitHub Copilot product was released. And it was just very easy for me to see. I mean, what's my business really, right? My business is I'm just a dude on the internet. I've been self-employed for 30 odd years, right? I'm a guy on the internet. I make things. A lot of them I don't do for money. Some of them I do. Sometimes people pay. Like, that's it. Like, that's my world. And as soon as these systems started to surface, it was just so easy for me to see that within 3 to 5 years, people like me are gone because it's just going to be so easy to create a fake person who's more interested in having, an X and a Threads account than I am. And, do you know what I mean? It's like, it's just going to replace folks like me. And it also became clear to me that my own personal work was in the data sets of all of these systems. And with the Copilot one in particular, right, that was a special case because I've been involved with the open source software world for 25 years now. And, it's easy to see that by creating this new way of accessing open source software, which is to say through a language model rather than through, let's call it like a community-based, interface like GitHub or GitLab or what have you, that, people's entire perception of open source was going to change. If any of you are involved with open source software for any length of time, you know that the economic problem of how to support open source software has never been solved. And it's really kind of crazy that that's the case, right? Because 25 years on, 30 years on, open source software is more critical to global software infrastructure than ever. And yet, it seems to be getting harder than ever to find funding for it. And for me, like this moving it into language models is just going to sort of threatens to collapse, that last, part of its vitality. So, yeah, I mean, for me, this is like an existential threat to what I do on the internet, and I think that the extension of this, again, that I could foresee, is that like I just don't do this anymore. Right? I'm not going to be able to do programming and typography and write, because it's just going to be obliterated by AI slop. And I'm not saying now, and I was right, but I think in the last 2 years, folks who are not me have started to see that, yeah, I mean, this rising tide of AI stuff that's sloshing around the internet kind of presents some maybe unforeseen consequences to folks. I mean, how has it been in academia? Like, how are you dealing with, generated papers, that are AI assisted, right? Has it been a problem as far as reviewing or reading things?
So I haven't personally come across AI generated papers in my line of work, but you can definitely see that they're starting to really infiltrate the lower end of academic publishing. So there are a lot of journals that are basically existing to help people get publication credits for universities that don't care what you do as long as you have publications. And those are getting hit with AI-generated submissions, some of them comically terrible. And it's one of these things where it's a disruptive innovation in the classic sense. It's going to start at the low end and just eat its way up. And I won't be shocked if there are people who are using these tools as part of their workflow. You see companies that are promising to help you find the citations for your work, and there are tools that will obviously polish your writing. So I suspect that many of my colleagues are already thinking about how to do this, and that might not be so destructive. It's the slop that I'm really worried about, because the AI slop is going to overwhelm all kinds of filters. Not the one person who crafts a paper with AI support, but the person who pumps out 100 papers that are garbage, but that take effort and time to filter out from whatever screening you're using.
Yeah, that's a great point. And this is consistently my experience with generative AI, whether it's code or art or writing, is that the time it takes me to correct the output, right? I feel like I'm just correcting a 12-year-old's homework over and over, and at a certain point I would just rather do the homework myself. Thing one. And thing two, you raise an interesting point where there's folks who are in positions of, like, they have education, they have experience, and they're like, well, if I just use this a little bit, what's the harm? And if you're standing athwart AI, you're like a gatekeeper. One of the most heartbreaking things I've seen in the last year, AI related, I wrote a little bit on my blog about Chief Justice John Roberts wrote a report last year, right, about the judiciary, his annual report, and he talked a lot about AI. And one of the things he said is that he felt that AI could possibly be a way of expanding access to justice for, people, indigent people. And I was just like losing my mind. I mean, the entire premise of our constitutional system of rights and the judicial system is that we protect the most vulnerable. And the idea that we're going to take the most vulnerable and give them the absolute shittiest possible tool to defend themselves is boggling. There was a video circulating, 6 or 8 months ago of a Ninth Circuit argument where the lawyer had plainly relied on ChatGPT or something like it to write her brief, and the panel was just not having it. They were saying, but this case doesn't exist, in this case, and it just was heartbreaking. But the thing is, the case itself was even more heartbreaking, because this lawyer was here. It was a case, as I recall, about kids who had been forcibly removed from their parents by the police. It's like, this is an important case, right? Like, that is exactly the kind of case we want to be litigated correctly. And yet, like, this is the case where, to Justice Roberts' point, right? It's like, and this is the kind of case that's getting ChatGPT. It boggles me. And it frightens me, because, I think that when you start playing out the trajectory, it's like the wheels start to come off.
There's a very serious set of initial inquiries now from a group of people who are starting to feed legal materials into ChatGPT and say, hey, this looks as good or better than what judges write. So why don't we turn things judging over in part to them? So there's David Hoffman and Jonathan Arbel have written a paper about asking ChatGPT to do contract interpretation. You give it the contract and you ask it a question, and that answers your interpretive question. Adam Unikowski has been feeding Supreme Court briefs into ChatGPT and then asking it to write an opinion that resolves this case. And it really feels like, as one of my collaborators says, vibes-based interpretation. Like, this looks kind of convincing, so isn't that as good as an actual opinion written by a human who thought about it? And it's actually quite terrifying prospect.
Let's say more about that, because when I talk about being scared about this stuff, I feel like I'm the only one, but you use the word terrified. So how do you find it terrifying?
So I find it terrifying because if your test for is this opinion a good judicial opinion is, does it read well? Does it sound convincing when you look at it? That just, in some ways, opens up room for judges to have ChatGPT write whatever opinion they want. They can say, I want to find for the defendant. Make me an opinion that looks ironclad that does it. And you've severed the link between, like, good faith judging and the output. They're trying to present the output as the inevitable result of well-supported legal reasoning. And if it's just whatever ChatGPT spit out, then it's not the inevitable result of valid legal reasoning.
Well, I think that's a great point. And I mean, I feel the same way about, I mean, I've talked about how, you know, I see AI as being the ultimate, like, laundering device for human behavior, right? Because, and I mean, and you kind of alluded to that in your great paper about the literate robots, right? I mean, how once machine reading has special privileges, that we create incentives to sort of funnel our reading through it. Am I mischaracterizing? I feel like
No, I think that's right. To summarize the idea, this was back in the days of Google Book Search and some other cases like that. The courts held that these kinds of ingestion of copyrighted works were fair use because Google was just using this to provide a search index. It told you what was in the books rather than sharing full books with readers. And this kind of automated mass consumption of books was basically not expressive. It wasn't the kind of thing copyright cared about. And a lot of the AI companies relied on precedents like that to argue that the mass ingestion that they've been doing has also fair use. The principle would be that bulk technological uses of works to recombine them in new ways are inherently fair. And I think that that equation breaks down to the extent that generative AI actually emits new things, that it produces new works that are also expressive that could compete with the works it was trained on. I mean, you have to go back to square one and ask, is this fair use under the traditional factors we consider?
Yes, I think that's a wonderful argument. I'm going to actually nitpick a little bit with you because you just said that the output of a language model is expressive. I don't think it is, and I think there's law saying that it's not. Did any of you follow this case, Thaler versus Perlmutter?
Yes. This crackpot inventor submits a piece of art to the Copyright Office that he says was generated autonomously by his AI with no help at all from him. He wants a copyright. The Copyright Office says, no, it was produced by a machine. That's not copyrightable. He sues, and so far he's been losing.
Well, yes, but it escalated to a district court case, and the judge in the district court said, sorry, sir, your work, you know, it's not copyrightable. But to say a work that comes out of a language model is not copyrightable is also to say there is no protectable expression in it, right? The output of a language model, as of right now, has the same legal status as a stream of random numbers. It is not expression. It is not protectable. The court said so. So I think, you know, it's kind of an interesting wrinkle on, or twist on the fair use argument that, yeah, a lot of fair use is about facilitating downstream expression, but that's not what language models produce. That was a sidetrack. I wanted to get back to, though, agreeing with you. I mean, I think you made that great point in Literate Robots that, yes, as these systems now become exactly kind of merge into the lane, or seem to, right, of what humans do with writing, these analyses become trickier. And I think that the effect that James describes, you know, of how these systems affect reading and writing are going to be writ large across the economy any time that an AI system is injected, right? people are going to allow the AI system to do the things that they themselves, can't do or won't do, and that is also terrifying. Because even today, right? I was reading a story about 6 months ago of a health insurer that was basically using AI to determine how long people could stay in the hospital, right? This sounds like, oh, they're just trying to cut costs. No, they're trying to kill their most vulnerable patients, right? They're trying to get them out of the hotel, the hospital, so they'll go die at home, and then they won't be a burden anymore. And then they can say, oh, well, but the AI made the decision, right? And this is going through healthcare more broadly. I mean, if you know any doctors, ask them. They will tell you that AI is infecting how certain procedures are approved by insurance. So this is going to be a widespread problem.
So I'll do one last question, and then we'll take any questions from the audience. Would that be different using an AI machine learning based model from a traditional hand-coded, constraint-based rule AI? Would that make a difference to how you think about it?
You mean, I'm sorry, like the two different kinds of AI?
Yeah. So in one case, the AI is learned from examples, and it's run a machine learning algorithm that nobody understands quite how it translates into the outputs. And in the other case, some programmer sat down and used a declarative language to write a whole table of what the output should be under various combinations and conditions of inputs.
Well, that's a wonderful question, and I think it's a question that occupies some of the biggest brains in AI right now, and has for many years. This kind of this question of how do we advance AI, right? How do we get to AGI or whatever it is you think is the end point? Is it by scaling up the language model, right, which is just sort of emulating patterns that it finds in its training data, or is it from this, what's called good old-fashioned AI, right, constraint, principle-based, working, kind of working from the bottom up, if you will, versus from the top down. And it's a big debate. I guess so if you ask me, like, as somebody who knows nothing, which camp I'm in, I'm certainly in the people who think that the only way to do it is from the bottom up. Like, I like math. I like, you got to work from first principles. That's the only way out.
Well, you like a different kind of math.
Well, yeah, maybe a different kind. So maybe there's some way to blend the two, but, certainly, what's appealing about these language models and generative AI art things, it's like they make things that are appealing and seductive, but as you say, often not even close to being correct in any way that we as programmers or mathematicians would care about. So, yeah, for now, I like the good old-fashioned AI.
Okay, thank you. Questions from the participants? Yeah.
We'll let him have a microphone.
You can have my microphone.
That's a wild.
And we'll run yours over here.
Okay.
Hey, thank you for this great conversation. So my name is Rohan Padde. I'm a professor at Carnegie Mellon University, and this is my first time, attending this conference, this workshop, or thinking about law. So I primarily do research in program analysis and like bug finding and finding security vulnerabilities. So going back to your sort of conversation about how lawyers sometimes have to think like programmers. You discussed various aspects of when lawyers are working on, let's say, like legal cases where you already have an existing law. There are obviously challenges with thinking programmatically. But I'm more interested in the process of creating laws themselves, right? So the legislative creation process, or maybe when you think like drafting contracts between two sort of business entities. I feel like as a person who's not a lawyer, a lot of the sort of challenges I've seen people deal with when thinking about like corner cases or edge cases, where you have things like loopholes or you have inconsistencies, often are similar to the kinds of issues we see in programming, where you have there's a specific intent by the authors to create a set of rules that should behave in a certain way. But then there are these edge cases that are not easy to reason about manually when one is writing them down, but then they end up becoming a problem once you have the system in production and somebody is able to figure out what this edge case is and then exploit it in a way that may not be the way that the original author intended. And then you get things like bees are fish eventually, where it's like a series of changes that are applied to laws that eventually end up being interpreted in ways that maybe the original creator did not want. So I guess there's a long context, but my question is, do you see in that process, in the legislative process, a opportunity for things like programming languages, formal methods, or even some some of the recent automation like large language models being useful in reasoning about what could go wrong, or what are the possible ways that this text could be interpreted that we aren't really considering right now as lawyers?
Thank you. I think I understand your question very well, and I think you're not going to like my answer, which is I think it has no utility at all, and not for the reason that you think. I mean, I think as a mathematical and programmatic way, it would be wonderful to be able to sort of check our reasoning of our laws. But here's the question. Is the point of our laws to be correct? And I would submit to you that it's not, right? Like you use the term loophole in your question, right? A lot of people use loophole with a note of pejoration, right? Where it's like that's a bug. Loopholes are not bugs. Loopholes are put into laws by people who want the loopholes there so that they can drive a truck through it later, right? We see this all the time, right? I mean, there is a political performative aspect to legislation, right? And the language that is on the page is a compromise between a bunch of different people, some of whom will want a certain outcome and some of whom will want a different one, and certain people who want the outcome to be ambiguous, right? A lot of times it's like we don't want to know what the answer is. We want to kick it down the road and see what a judge will say because we think, so I think if you stood up and said to a legislature, like, here, I can completely like software automate all of your legislation, would you like that? They say, no, thank you. No, we'd like to keep things a little wiggly and wobbly. What do you think?
So I do actually like some of Sarah Losky's work in this space, where she's tried to identify the kinds of ambiguities in tax laws that there would be no plausible reason for anybody to want. The questions of, does this term scope to a paragraph or to a subparagraph? Or cases in which there's simply an ambiguous referent, and it refers to one of two things, and we just need to figure out which of two things that term refers to. So I think like some of the cross-referencing kinds of issues probably are eliminable ambiguities. There are other cases where like ordinary and reasonable, we're never going to automate ordinary and reasonable as a term or commercially reasonable efforts in a contract. Like the smart contract dream of getting all ambiguity out is a fantasy. But I think there are some kinds of very clear, almost syntactic errors that it wouldn't hurt to be able to at least lint out of the process.
That may be so, and probably tax law is a great example, but also sort of special, right? As I indicated before, it's, if anything, the part of the law that is most susceptible to, just being considered something of a software program. Though not strictly, lots of deliberate ambiguities in the tax code as well, for those who are interested.
Tiffany.
Hi, I'm Tiffany Lee. I'm an associate professor at the University of San Francisco School of Law, and I have kind of a small or a big question. Do you think open source licensing actually works with LLMs, given that we have so much data, and if you want to open source it, are you going to open source every single data set that is used to train an LLM? Is that even practicable? And secondarily, is that in line with the ethos of FOSS? Right? Are we thinking that current AI, owned by these tech companies, is still something that we can ethically consider part of an open source movement?
Well, what's your view? I mean, but finish the thought, please. Like, what's your thought on that? I mean, I know like the Open Source Initiative is considering this issue right now, and Meta is resisting. So, I mean, what are you thinking about it?
Yeah, this is something that I've just been trying to figure out for myself. So I would love to hear any of your thoughts, because it seems like, I would love to have open source still be a thing moving forward, right? But then if you're considering, what does that license look like? Are we open sourcing model weights? Are we open sourcing every single data point you use? How can we possibly enforce that? And then I was thinking, the AI companies now, they're extractive, they're exploitative. Is there any point in trying to make them moved back towards an open source, respectful model? Is there some way forward, even in this new environment that we're in, this sort of corporatized AI environment? Like, what do we do now?
Well, I can give you my, again, I'm like a big open source fan from long time ago, and it may be that my views are completely obsolete and I should just drop dead. But I think like open source should mean something, right? And I think we do see this problem right now in AI that a lot of people are throwing around the word phrase open source and just kind of deciding it means whatever. I actually, in a funny story, like one of the nerdiest moments I've had working on these cases was about a year ago. I was in a courtroom. Judge Orrick up in Northern District of California, we were at a hearing about the stable diffusion model. And he said to us, hey, it's an open source model. How is it that you weren't able to go figure out X, Y, and Z about it? And my co-counsel said, Butterick, go up and answer this question. So I had to give a little talk to the judge, who was wonderful and very technically minded. But I had to say to him, well, Judge, yeah, you're right that the software itself may be open source, but the weights file isn't, right? It's like a Nintendo and a cartridge, right? You need them both to work together. And unless we can see what's in the weights file, it's not really open source. And he's like, all right, I buy that. But it kind of goes back to your question, right? How much of these systems need to be open? And I think actually it is kind of a dumb game that they are open sourcing, whatever, the inference and training even, but not the data. So I think where the OSI is coming out, didn't they just recently say that if you're going to call it open source, you need to open source your data set as well? Isn't that kind of, or at least disclose it? I think that's the right answer, right? I mean, to me, open source software means you can, download it and you can run it yourself, you can build it yourself, and you can modify it. And for a machine learning system, that has to include the training data, right? So if you don't have access to the training data, you've only got a part of a system. And I think in the previous world of open source, if someone said, if Microsoft or Apple or someone like that had said, here's our open source software, it's all open source except for this 80%, we'd say that was pretty shady.
Yeah, I think that there's a crisis in open source right now. It's coming on a lot of fronts. One of them is the economic sustainability point that you mentioned. But another one is that with AI, suddenly the definition of what artifacts you need to make it open source is ambiguous a bit in a way that it didn't used to. Second component is that it's not obvious what things the license attaches to because the copyright in them is complicated or non-existent, depending on how you look at it. And then the third is that the underlying power relations of who is able to do what with what don't cleanly map onto the way that open source worked for decades, where the idea was if you had the source code and you had the legal right to work with it, you were free in a meaningful way to go do it on your own. And when you are looking at data sets and models that take millions of dollars in compute to train, suddenly that's not quite the same freedom that it used to be.
Great, thank you.
Can I add one more thing? I don't know if any of you remember the Affero GPL, AGPL, and why it came to be, right? But this was a struggle back in, I think, the late 90s. The GPL software was starting to be used on internet servers as sort of the early cloud-based services. And what the GPL folks were realizing is that it kind of amounted to a circumvention because you could deploy GPL on a you know what I mean? You weren't sending it to users, you were keeping it on a server, but it was not preserving the sort of open sourceness. So the whole point of the AGPL is if you use the program on a server, you still have to distribute the source code. So I don't know, maybe we're going to reach a place like that. It's weird, right? Because open source licenses kind of traditionally can't discriminate against types of use, right? So, forbidding people from using an open source software for AI training, is its own struggle too. So I'll be interested to see what the OSI comes up. It's a knotty problem. Thank you.
So I think we are going to stop it here so we can go on to the scavenger hunt. So let's thank Matthew Butterick.
All right. Thank you for having me.
Thank you. So we are going to continue now with our first social and getting to know each other event. Can we put the slide from my computer up on the screen now? So we have a bingo and scavenger hunt event. There is also a link to this. Oh, yes. I'm sorry. Yeah. It's totally my fault. Okay, it's plugged in. Let me check my displays. That should set, it's set to mirror. Okay, is it visible now? Go ahead. There is also a link to the bingo form in the program for the day. If you look under the bingo hunt, scavenger hunt section in the event, you can see the link there to click on to make your bingo board. Hello, everybody, and welcome back. We're going to start our paper session. So we're going to have 2 papers followed by a discussant, and then repeat. So here with the first presentation is Saeed with Metamorphic Debugging for Accountable Software.
Thank you for the introduction, and hi everyone. Welcome to this session. I'm going to talk about metamorphic debugging for accountable software, and I'm Saeed Tisbazniari, working as an assistant professor at UTEP. So we know that software has been deployed in critical sector of our society. For example, decision-making software has been used for parole decision to measure the risk of reoffendment by defendants. For the tax return, we usually use tax preparation software, and IRS, other organizations, they use tax auditing to determine, using software to make auditing decision for tax return. Various local and state government, they use poverty management system to give different benefits for citizens, especially the low-income vulnerable citizens. And also for forensics DNA software is kind of primary tools to make various prediction and computation. So given this socioeconomic and legal implication, it is important to ensure software accountability. Of course, the software accountability is open to interpretation. We defined in this work software accountability comprised of the properties of legal compliance, trust and procedural justice, fairness of outcome, and confidentiality and privacy. So if we achieve, if we show that software satisfies this property, we can see this software can be served as a surrogate model to inquiry about legal and social norms in same way that software engineering conduct the test. But doing so is very challenging. So we have a lot of anti-pattern example. For example, here we have Probabilica found that DNA software used by multiple states, they have an unclosed function method that was not documented as a part of software development, and this method kind of randomly remove evidence from the sample from the evidence, and this can lead to false inclusion of the people, and the people can go to prison while being innocent. So they, in some preliminary results, shows that 23%. Close to mic, sorry, yes. They show that in about 25% of cases, when this method was triggered, the results are skewed toward false inclusion of the individual whose DNA was not present in the crime scene. And there are more resources on that. Similarly, for tax preparation software, we know that governments provide various support, especially for vulnerable taxpayers who, for example, eligible for earned income tax credit. And any error in this sense can lead to catastrophic outcome. So we have some example of people who were eligible for EITC, but software was not able to determine their eligibility. For example, the case of Tax Slayer Pro. Finally, when we are looking at the data-driven software, it's also important to ensure the fairness. So we have very famous case of Compass software, where it had a higher false positive rate for African American compared to other racial group. So people who had done very benign offenses, they receive higher risk solely because of their racial background. And same way, very recently, a group of researchers found that there's disparity in the tax auditing, where Black Americans who were low income and eligible for earned income tax credit, they were audited at the rate 3 to 5 times more than others. Okay. So what are the challenges of approaching this issue to ensure the accountability of the software? So one challenge, as we discussed in the previous session, is the fact that they are coming from some written law and policy. So there can be a lot of issue within the written law that, for example, allows people, especially privileged individuals, to exploit loopholes. They have more resources to find how to kind of reduce their burden, and also various inequality that are manifested in the law itself. Then there is a perception of the citizen when individuals are approaching this software. What are the procedurals of the justice, whether it is free of confusion, whether we can explain the decision of black box system. And finally, when we are going from the executable law as a software code, we often face oracle problem where determining the ground truth of outcome is highly challenges. So we don't know really, for example, in the tax system, given a profile of taxpayer, what should be the ground truth tax return. And we don't have the trustworthy data set to rely on them because obvious privacy and legal concern. So one key observation that we make in this position paper to say that while the output for a given input may be unknown, the relationship between the output between two related individuals may be easier to express. So as an example, to say that while we don't know for an individual X of X1 who is blind, what should be the ground truth tax return, we can say that among two individuals that exactly have the same profile, one is blind, one is not blind, the individual with individual who is blind should receive higher in tax return. So this kind of relating cases to each other resembles a legal doctrine of precedent that requires the similar cases to follow similar outcome or similar verdicts. It also resembles the notion of vertical and horizontal equity in taxation, where we can look at individual on the similar income range and individual with different income level and establish relationship between them. And finally, especially for the sake of this talk, it resembles metamorphic relationship in software engineering that basically establish the correctness by relating inputs to outputs. So we define metamorphic debugging in this work as a foundation for detecting and explaining and detecting, explaining, and repairing socio-legal software with respect to metamorphic specifications. So there are three multiple stages, like what is the metamorphic specification, how we can detect bugs using metamorphic specification, and how can we explain them. So in our early initial work, we kind of use a manual procedure to extract metamorphic specification by looking at the various publication of the IRS to see that what are the eligible conditions and how the different people might relate to each other. So some early specification of metamorphic relationship are reported in our early work, and we recently also explore whether these metamorphic relationship can be extracted using the advancements in large language model. You can read more about this work in the following citation. And one thing that is nice about metamorphic specification is that it allows us to also consider multiple year specification. So if the law is changing over the year, we don't need to change the entire specification unless there are complete changes in the policy, and we can just update that portion of the law. For example, maybe AIG requirement for EITC changes from one year to another. We can just update that part of the metamorphic relationship, even more easily can be done using large language model in this case. Okay, so if we assume that we have this specification that by itself is a hard problem, then the next step is to kind of explore this metamorphic, the space of this metamorphic relationship. We come up with our preliminary work. We come up with this randomized algorithm where it's randomly generate test cases from the space of the inputs to satisfy the premises of metamorphic specification, and we found bug if the conclusion of the relationship does not satisfy it. Once we got that, so we can actually see this as a debugging. We can use some white box model to gather cases that are failed and pass, and use, for example, simple decision tree to understand under what circumstances a software fails to satisfy the requirement. So this is like a whole metamorphic debugging cycle for a tax preparation software that we present is to come up, to go through the tax line policy, come up with the scenarios, specify metamorphic relationship, and then guide the search to find bugs and hopefully explain if there is a bug, what are the root causes. In both space of the inputs and program internal, this can be done. Similarly, metamorphic debugging can be used for poverty management system. So this is work that reported in CSCW 2020, where they found that a poverty management system used by Pennsylvania state called Do I Qualify? They basically had some problem, and the way they approach this is to consider the online version and the ground truth software and compare the outcome of these two together to realize if there is a bug. So it's kind of this input that's generated for these two software, they're syntactically different, but semantically they represent the same cases. So from the experimental result, here are some of the results that we reported using our randomized algorithm on the 16 metamorphic relationship we had. So one interesting thing that I can share, there was this bug in EITC. That we found in the open tax solver. It's open source implementation of tax law for the US, and it is kind of was faulty for 1 year, but it's not faulty for another year. It turns out that kind of the policy has changed throughout the year, and software was not satisfying it was compliance, let's say in 2020, it become compliant in 2021 due to change in the law. So overall, we kind of observe some number of bugs that we can basically fix in this software. Similarly, for poverty management system, they tested this Do I Qualify software in 4 domains: healthcare, food assistance, cash assistance, free or reduced price school meals, and subsidized childcare. And they found that in the subsidized childcare, there was about 5% of household testers that they should have been potentially eligible to receive the benefits, but they were not. And also the root cause are not pinpointed, but that was a kind of a suspicious fault in the software. So there are many, as we are here, there are many interesting future direction in this area. There are part that we can look at from the legal side, from the psychology side, and from computer science side. So mostly from the computer science perspective, there are opportunity for large language model, use them for extracting legal specification in the form of first order logic. It's still not a solved problem, it's a hard problem itself. Technique like smart fuzzing can be adopted in these settings to ensure the correctness of them, but they should be extended. For example, in this domain, it's not just control flow sensitive search is important, but data sensitive search is also important. Also, there are opportunity for using causal graph and probabilistic programming languages to come up with a grammar-based racy randomized testing, explanation, debugging that can be aided by these techniques, and they are good opportunity to explore as a future work. Okay, I think that's how much I wanted to share today. This is an ongoing work as a collaboration between UTEP and University of Colorado Boulder. Want to also acknowledge NSF that the grant we got from designing accountable software system enable us to do these various things. And the website for the project is there. I would be happy to share more things in the future, but we just started to exploring the various aspects of accountable software in this case. Thank you for your attention, everyone. So I will be happy to take questions later. Question later, right? Okay.
Okay, and next we are going to have large language models for executable tax code generation. Sam, you're going to be presenting? Both of us, Sam and Vasu.
You need to turn off true.
Oh, yeah. Okay, how do we not touch this thing? Mouse disappeared. Yeah. How do I make it mirror? Do you know? Mirror. Oh, mirror. Okay, great.
And speaking to the mic. All right. Hi, everyone. My name is Vasu. I'm going to be presenting jointly with Sam. We're both PhD students at Carnegie Mellon. And today we'll be talking about large language models for executable tax code generation. So let's start off with some motivation. I'm sure as many of us attended the interview in the morning, large language models have been starting to be used for a wide variety of tasks and reasoning tasks. One such example is tax code reasoning. So I took this screenshot from like over a year and a half ago now for when GPT-4 was first released. And one of the kind of demo examples that they want to highlight was the user was instructing GPT-4 in the playground that they're called TaxGPT, a large language model trained by OpenAI that is fed in the entire US tax code. And they are given a particular scenario. Alice and Bob got married and are filing jointly, et cetera. And it's asked to calculate their standard deduction for 2018. So this was, LLMs for legal reasoning, it's getting more and more popular, but obviously, as we've talked about, there can be problems where LLMs can hallucinate. And as Matthew mentioned initially, this can be a big problem for legal reasoning. So here I've included an example for Alice and Bob filing taxes jointly for 2025 and asking this standard deduction calculation. And if you were to prompt Claude, which is a popular off-the-shelf model, to break this down step by step and reference all the US tax codes that have been provided, it will actually end up with the incorrect answer because in one of the steps it forgot to take the correct number for filing jointly. It took the individual standard deduction. So LLMs can hallucinate with these, incorrect mathematical computations or fetching the wrong number, fetching the wrong information for these reasoning tasks, which is why LLMs have also been used to generate code to solve a lot of these issues. And one such example of a programming language in the legal domain is CATALA. So CATALA is a DSL for formalizing legal documents. I'm sure many of us have used CATALA in this room, and we actually later on have another talk that does concolic testing for CATALA. But the general premise for CATALA, it has a very unique syntax and semantics that's kind of designed with encoding legal documents in mind. So here I have a very basic example of a scope, which is similar to a function in another language for calculating income tax. And in this case, we initially define income tax as our gross income minus deductions. But CATALA has a very nice feature called exceptions that you can write later on in your CATALA file that can essentially override the rule that you originally defined. And we're going to refer to these types of features as idioms, and Sam will talk more about idioms later in the talk. So in this case, our exception will check the condition that the individual's income is less than $10,000, and if so, the tax computation will return 0. So naturally, we asked, can we use large language models to generate CATALA code directly as a way of performing these tax code executions, instead of rather using the LLM as the reasoning model and calculator itself? And what we found, so we performed a variety of prompting strategies and studied 3 different popular off-the-shelf models. And we specifically looked at the statutory reasoning assessment dataset, or the SARA dataset, which has a lot of these sections of the IRS tax code and associated tax cases to sort of test these different scenarios of each section. And somewhat unsurprisingly, we found that the LLMs often produced syntactically and semantically invalid CATALA. So as I showed before, CATALA is a very unique syntax, and we also kind of jokingly refer to CATALA as a no-resource language, in quotes. You may have heard of low-resource languages like Rust and other things in which there aren't that many examples on the internet. CATALA has a magnitude fewer amount of examples on the internet, which means that LLMs have not really been trained on the syntax and semantics. And we can kind of summarize our results with all of our prompting different strategies with this plot, where we see this, in the land of programming languages, Python, Java, C#, Go, LLMs can perform pretty well, both in producing syntactically and semantically valid code, but we found sort of the opposite side of the spectrum with CATALA. And we generally observed that all these different prompting strategies, like few-shot prompting, including a few examples, or self-debugging, allowing the compiler to return an error message, and reprompting the LLM, or providing better documentation in the context window, overall improved the syntactic validity of the LLM-produced CATALA code, but didn't really change the semantics that much. And throughout this experience, we also worked a bit more with CATALA. We're not experts by any means, but we tried to sort of manually translate a lot of these sections of the tax code into valid CATALA programs. And we noticed a lot of observations, as well as observations in the LLM outputs. So in particular, one thing that we kind of struggled with was how natural language has a lot of implicit context, especially in the tax code. So I've included a small snippet here from section 63 about taxable income. And in this case, I'm showing the same example where gross income minus deductions allowed by this chapter would be the taxable income. And in CATALA, you sort of need to declare all the metadata for your scopes, essentially the structure, all the inputs and outputs, before actually defining how that scope is calculated. So in this case, we've sort of hard-coded all of the inputs that we need in order to calculate taxable income, which includes gross income, standard deduction, personal exemptions, itemized deductions, et cetera. And then the issue here is that the deductions allowed by this chapter could be defined in a different section. In this case, it's in section 151, that we would need to essentially modify how we defined our metadata from before later on when we actually translate section 151 into CATALA. So with that, I'll hand this over to Sam, who will talk about sort of more of our observations and what our approach to kind of solving this implicit context example is.
Yeah, so there's nothing in particular wrong with this translation just by itself. It's fine. It makes sense. It's correct in a certain way. The problem is in how we're able to use it. So the SARA dataset also provides a bunch of test cases. And so this would be an example. So you provide some information about some fictional people and data about them and their income and things like this, their situations. And you want to translate this into a way that you can actually invoke the CATALA code that you've written, right? And as you remember here, this scope has a whole bunch of inputs, and then it has this output, which is the taxable income. So it assumes that you've already calculated all these particular inputs, and you provide it to the CATALA code. And so that's fine. It works in this case. There's no problem. But what if you were provided some different information, right? What if you were provided, instead of these are the deductions that we've already calculated, what if you were provided oh, Alice and Bob have been married this long, and then there's this other information that you could use in theory to plug into some other section of the tax code. in this case, it's a bit more unclear, right? And so like, this isn't that hard to do in this particular example. What you would do is you would go look up the other sections of the tax code that are relevant to this data, and then you would call those scopes, and then you would use the outputs of those scopes as inputs to the scopes. But that's a little bit like weird that you have to do that, right? Because I thought that like the whole point of trying to translate this into a programming language is that it should be able to calculate it from the information that we give it. But then now when we're translating the test case, we have to translate all this sort of like plumbing and connecting functions together in the test case itself. So there's a lot of limitations in how you can actually like what you can do given a CATALA function, and having to write this this like plumbing information yourself introduces a lot of room for error and a lot of extra complexity. So we did a couple of little experiments, and these aren't like nearly like production grade. These aren't even like anywhere near to like the level of sophistication as CATALA, but they kind of suggest a couple interesting ideas that we want to hear the thoughts from this community on. So rather than thinking about this as like a function in the standard like functional programming sense, we could think about it as a computation graph. So here we have like the gross income, we have the deductions, we have the taxable income, and maybe some of these nodes could also be computed from other nodes in the graph. Like you can see there's an arrow that kind of goes off screen. Like if you have the deductions in hand, you can use that. And if you don't, then you could compute it from something else. And the graph, the structure of the computation graph says how to compute things from other things, regardless of which things you actually have. Like as long as you have enough, it can compute what you want. So we designed a domain-specific language. This happens to be embedded in Clojure, which is a Lisp, but that doesn't really matter too much. It was just easy to prototype. And so the way that we define computations in what we call Dagger is you declare nodes in the graph, so like gross income, deductions, taxable income, and then you can define ways to compute those nodes from other nodes. So in this case, you can say, if you don't know what someone's taxable income for a given year is, you can compute that by subtracting the deductions from their gross income. And there's a couple things that are nice here. So one thing that is that this kind of looks just like saying like if gross income and deductions were variables, kind of like what they were for the CATALA example, this code looks roughly the same. But if they're not provided as input, and if instead you provided data that you could use to compute gross income and deductions, it will instead compute them. It will see that they're not already present in the computation graph, and it will compute them. And it will pass down implicitly the context of, I'm talking about a particular year and a particular person to these sub-computations here. So this question mark operator automatically passes down all the context that's shared between the node you're currently at and the node that you're trying to compute. So the code just looks natural, and this implicit context is only present in these declare directives here and not actually in the definitions. So the structure of the code mirrors more closely the structure of the original prose, despite allowing more flexibility in how it's used. So this is kind of like, this computation graph is like changing the paradigm from like functional programming to this like computation graph idea, incremental computation. There's like a lot of people who have done work on this before, like Adapton and Salsa are a couple examples if you want to look those up separately. But the nice thing is that we're also able to retain, we talked about idioms before. CATALA has these useful idioms like conditions and exceptions, things that are common in like legal prose. And we're able to retain those as well. So we call them cases instead of exceptions, but it's the same idea. We could call this exceptions instead. And in Dagger, you're able to say, like, if this function returns true, then like for this rule, we return a different value. So the idea here is like essentially, yeah, I'll kind of skip over this slide because we don't have a lot of time. But the idea here is essentially like by changing the paradigm to like a different way that matches like this legal code more closely, but retaining some of the axioms from the idioms that we already know are useful from CATALA, can we make a language that's more straightforward for humans to write and translate legal prose, and also closer to the legal prose itself, so that large language models have an easier time doing it as well. And we don't have a sophisticated evaluation here. This is kind of early stage work, but yeah, that's pretty much all we have. Plug for Rohan's talk later this week, which is on like a similar idea of like, can we get the LLMs to like, do the reasoning yourself? So definitely come check out that talk on Thursday. And yeah, that's pretty much all we got.
Okay, and then we need to get Sarah Losky in for discussion. Now we're going to have Sarah Losky as discussant. We don't have your audio yet. Just a moment. Nope, not yet. Try again.
All right, how about now?
Yes, great.
Excellent. All right. I'm getting an echo here, though. I don't know if someone's able to help with that. All right. I think I may just have an echo. All right. Well, thanks for these two really interesting projects. I'm going to try to keep my comments very short, just to have a few minutes to raise some ideas from the audience. But I also understand that after this, folks will be going to lunch, and so maybe there will be some time for people to chat then. And I really wish I could be there in person, and I'm sorry that I can't. Okay, so I'm going to talk about this from the lawyer perspective. And though I think there were a ton of really super interesting ideas from the computer science perspective as well. And what I'm going to suggest is that when there are papers like this that cross over that come at the intersection of computer science and law, it's going to be much easier for lawyers to hear the project if what they hear from the law side is consistent with what the law side to be. And it so sometimes this will be like some just basic so I think when there's discrepancies, even if it doesn't get at the core, the discrepancies sometimes are just going to make it between what a lawyer understands the law to be and what's being described. Sometimes the discrepancies are just going to make it harder for the lawyer to sort of like understand the project or engage with the project. And sometimes it might, the additional legal knowledge might actually change the project, but it's hard to know until you actually sort of engage with that. So for example, in the metamorphic debugging paper, which is super interesting, the tax law is an interesting one to use as a black box where we can't know what's inside, because the U.S. actually does reveal the formulas that it uses to calculate tax liability. And in fact, I would suggest that some of the metamorphic tests that are described or can be described only because the law is so specific. And so what's going on when you have this tax software is that, especially, I mean, all of the tax software, but especially that free tax software, they're loading in the forms from the IRS. That's it. So the IRS is giving you the specification in algorithms, and it's those algorithms prepared by the government that the tax preparation software relies on. The software is based directly on the forms. What's subjective about the tax forms, which I absolutely agree, there's a lot that's subjective and ambiguous about the tax forms, but that's not captured by the metamorphic testing either, because what's subjective might be what goes into the inputs. So return preparation software is just doing like a portion of tax preparation. It's the part that requires, as accurately described, the accounting and legal and ethical advice. That's what determines the inputs. But by the time you've made the assumptions for what goes into the metamorphic testing, because the way the software is set up, you've pretty much assumed away those ambiguities. So I'd be curious to hear more in that test that failed, because I think it will be some difficulty determining the metamorphic tests. You say, well, we can't know, it's a black box, but of course you can know. You have to go to what the law is. The law is telling you exactly what they're going to do. And I think what happened there was the tax form changed, and the open source tax software kind of notoriously, I mean, they struggle a little bit, and they probably just didn't do the form. So that's kind of like but when you talk about this stuff, you want to make sure to be, it wasn't a change in tax policy. Maybe it was a change, I don't know exactly what you're referring to here. Maybe it was a change in the actual law, which wouldn't be a change from the IRS, it would be a change from Congress. Maybe it was something about inflation. I don't know what happened there, but I think what happened was the form changed and it didn't make it into the software. So it just, that's sort of like a pretty specific point, but I guess my more general comment is, if things are said that don't line up with what lawyers understand, it's going to be much harder to be in conversation with lawyers. So it's things like that, things like what, is tax law common law? Not really in the United States. It comes from statutes, and just sort of details like that. If you're going to talk to lawyers, you have to say things, the parts that lawyers are going to understand have to be consistent with what lawyers know. I thought that actually this was a nice, that paper is a nice bridge to, I think, one of the papers coming up. Because the law is so specified, sort of query whether we need to generate these purely random tests or if there's a more organized way to check the tests, and I think we'll hear about that in a few minutes when we hear about concolic testing. For the paper about the executable tax code generation, the LLMs for the tax code reasoning is actually a great example, because that's a very famous example that the authors of the Sarah set wrote a great article about, where that was like, that example was wrong, and I'll put a link to that I'll put a link to their article in the Discord chat. That is a very famous example, and it's famously disastrously wrong, as the authors of the Sarah set themselves describe. So it's a pretty funny article. So I think that for that, that was, I think that's a really interesting sort of beginning of the project. And I think that the questions that lawyers are going to have are, first of all, you talk about using the Sarah data set. I think if your claim is going to be that this is able to be translated, that the LLMs are able to translate into this language more easily than into other languages, I think the first question is, well, is it going to be the real tax law or not? I think that the Sarah data set is an interesting interim step, but I think a lawyer is going to want to know about that it can actually do the actual language of the Internal Revenue Code. And I think I thought it was really helpful to hear more about how the generated language tracked the actual statute. I think that was really helpful. I think that a lawyer, that's a kind of a question a lawyer will have. And then I think that there's going to, people are going to want to know how easy will it be for a lawyer to verify that the language actually tracks the statute. So I look forward to learning more about this DSL, to seeing a little bit more a specification of its syntax, and if there's an underlying semantics, and if we can know something about we're able to prove things about stuff in this language or not. So I think these are two really fascinating projects. I want to stop talking now because there's only 5 minutes before the next folks are supposed to start, and I want to leave a little bit of time for just some maybe questions or provocations from the audience. But really appreciated the opportunity to read and think about both of these projects, and I'll look forward to seeing where they go.
Noted. We have 5 minutes until the next papers. So if the authors of the first two would like to give any brief responses, I think it would be a great chance for that.
Yeah, thanks. Thanks for the...
Is it on?
Okay.
Yes.
Okay. Yeah, thanks for the comment. That was great. Just wanted to clarify that the metamorphic relationship is not really ambiguity of the inputs that you mentioned. It's like more on the implementation of the code. If we are translating the tax code in the software code, how to ensure that they are correct. And the issue that we are facing as a software engineering is that we didn't know ground truths for each individual. What will we expect as their tax return? So instead of looking at them individually, we relate them, saying that, oh, if it has higher standard deduction for blind, it should have this property between these two individuals. One is blind and one is not. And same for the other cases as well. So that is the idea, at least in the work that. But of course, the metamorphic specification goes beyond this, and it can be looked at like a disparity between the different racial groups by relating individuals who are similar, but they have different background, and see what are the response from them. So it's kind of.
Yeah, thanks. Hello? Oh. Yeah, thanks so much for the comments. I guess, yeah, I don't have a ton to say. Maybe Vasu has a bit more, but really appreciate the like lawyers' focus on this. Yeah, I think that like semantics are something that we've thought a little bit about. Like, can you structure this sort of computation graph in a way that you can like analyze and say things about? The evaluation question is like, we would definitely like to be able to do this on like the actual tax code. I think the question is like, if you get the LLM to translate like a large chunk of tax code to a language, and then like maybe you can run it, but like how do you actually check whether it did it right? If it translates the test cases as well, then did it translate the test cases as right? So that's something that we're a bit unsure of how to do, but it would be cool.
Yeah, I think the SARA data set is like a nice entry point into looking at evaluating these natural language models on this particular task. I think it kind of pointed us in the directions of like where we personally, when doing these translations, like struggled with writing CATALA code. A lot of the kind of gluing together inputs and scopes together was one of our main difficulties, and one of the things we observed with LLMs. I'm sure that those will continue when translating the overall tax code. And so I think like our experiences with the SAR data set, I think were good to kind of motivate the overall direction of Dagger in thinking about this like DAG computation. But yeah, I think we could also definitely look at how lawyers and programmers kind of pair program CATALA and like where they find difficulties as well as another way of kind of thinking about the language design.
Okay, I think we will move on to the second set of papers. So I believe next up we have Paulus Mason presenting cross-disciplinarity in contemporary code-driven legal informatics.
Okay, good morning. Can everyone hear me? Great. It's auto-playing, which shouldn't happen, of course. I'm going to talk about cross-disciplinarity in contemporary code-driven legal informatics, and I'll explain what this is. First, who am I? My name is Paulus Mason. I'm a PhD candidate from Radboud University in the Netherlands, where I worked on the Cubicle project for the past 5 years. And I'm currently also working at the Autoriteit Persoonsgegevens, which is the Dutch data protection agency. So the motivation, I was working on this Cubicle project where we are interested in how law is changing in contemporary times, how it used to be a discipline that was based on a technology we're very familiar with, text. And all of a sudden, we are building applications and code and data systems where it's no longer a text-driven system, but maybe a code or a data-driven system. And with that, as we also heard in the discussion this morning, you have to resolve a lot of the features, the design aspects, and the procedures in law based around the open texture of natural language in order to get something into a machine. And obviously something gets lost. And I was very curious to get into these communities of contemporary legal informatics. I've put up here the Journal of Artificial Intelligence and Law, the Jurix conference, the IKIL conference, of course ProLaLa and more, and was hoping to find interdisciplinary or cross-disciplinary, as all of these conferences advertised, collaborations where lawyers and computer scientists together figure out these stresses, this contrast between the fact that text can do stuff that code cannot, and vice versa, of course. And as Professor Grimmelman put in his research agenda originally for the first ProLaLa conference, this is a very exciting field where these come together. There are many similarities and many differences. But I was very disappointed. I didn't find the right sort of interactions, and this got me curious. So I formulated some research questions or maybe hypotheses that are at core of this disappointment that I ran into. And I was wondering, like, is legal informatics no longer a cross-disciplinary research field? Are valuable contributions from legal informatics lost, both for solving human critical problems and understanding the underlying normativity? And in legal informatics, do we care more about the technological process, more about than solving problems that are actually from legal practice, from administration, or clearly about the law? And as such, I set out to investigate. I dove into the papers and made a literature review, the results of which I am going to present today. So the outline of this presentation. First, I'm going to explain a little bit of the conceptual framework, because I don't know how excited you were about my title, but what is cross-disciplinarity, what is contemporary legal informatics, and what do I mean, code-driven? Then I'm going to talk about the actual literature review that I did, the corpus, the questions that I asked. I used a little bit of LLMs in that, and I will, of course, talk some more about this. And then, of course, I have some results and some discussions and recommendations. So this conceptual framework. One of the things that you notice is, and we've seen this in the same conference, that a lot of the influx in our field of legal informatics is from data-driven methods. It is from machine learning and LLMs and generative AI and statistical methods and data science over time. And in this figure, I plotted for the 500 papers that were written in Jurix, IKIL, and the Journal of AI and Law. Basically the trend of how many of these papers were data-driven, which is the yellow part, and how many of them were other. And it's an upward trend. And I think, especially in this programming language community, where we see that a lot of problems in conventional classical code still need to be solved, that we cannot necessarily use all of these new problems that the data driven methods introduced. And as such, I decided to focus on code-driven methods, which for the context of this presentation mostly means non-machine learning, non-statistical, conventional modes of code, as we see as a canonical example in this field almost is text automation. So this code-driven law, what I really am excited and interested about is systems in or related to law where the normativity is shaped by code. So that the effect on legal effect is shaped by the way we write the code. Whereas in data-driven aspects, it is the data that shapes it. Then, of course, I talked about cross-disciplinarity, which for the nature of this experiment, I simply want to talk about people who have a discipline related to computer science, or people who have a discipline related to the law. And of course, in the field, there's many philosophers and language experts and different brands of computer science and engineers and mathematicians. But I'm going to make this reduction to say that there is a computer science cohort and a law cohort. Then I introduced two new terms. I'm going to say question pool is about articles or research that have an immediate research question, in this case from law, central to the research, to the paper, that needs to be solved or analyzed. Then there's also the notion of technology push, which is having the development or application of a new technology or innovation as core of the research. I originally thought these were going to be mutually exclusive, but as I've seen, there are some people who manage to do both in their research. I've colored these orange, which you'll see later. So then let me talk a little bit more about the methodology, because ultimately I did a literature research. So I'll talk now about the corpus of work that I looked at, the papers, and the question framework for the deep analysis of the papers that I selected to focus on. So from these leading publications in the field of AI and law, and this word leading publications I have from others, so this is what motivates my choice here. From ICAL, I had 222 papers that were written since 2015. Jurix had 514 papers since 2005. And AI and Law had 141 papers since 2017. So originally I started with 904 papers in total, which for an individual research project was a bit too much, so I needed to make a shift in that. And I've done two things for this. One, I used an LLM to relabel the data set with new keywords for data-driven and code-driven to make sure that I could focus only on the code-driven papers. And I decided to focus on just last year, 2023. So in 2023, from these communities, we had 143 papers that were published. And LLM labeling allowed me to reduce this to 56 code-driven papers. 25 from Jurix, 17 from ICAL, and 14 from Journal of AI and Law. Some interesting facts about this selection of final papers. They're written by 135 unique authors or co-authors of these papers. It is a truly international community from 24 different countries. 9 of these countries are from within the EU. 18 of these authors appear on more than one publication, which also has to do with periodicity in which they appear. So some people have evolutions of their research that is published in in a few of these different outlets. And 2 authors were author or co-author on 18% of the corpus. So on this GPT labeling, I used it to add the keywords to the section. It is sort of related to a traditional LLM task, labeling. I tried it first with GPT 3.5, which just wasn't able to do the job, but GPT 4 seemed to give good results. Try to use some of the best practices such as prompt engineering to make sure that it would reason about what it was doing and therefore reinforce some of the attention in the labels. And I used the API, so I could have at least a log or a transaction of the actual interactions that I had with these models that are run by external companies. And then the bad, of course, is that ultimately turned out, once I did the close reading, that it had 91% accuracy on the 2023 data set, which for false positive labels. And of course, it's very tricky for the reproducibility of science, that you cannot make the same queries and get the same results or apply this to a broader sense. However, I was very excited that this allowed me to, as an individual, tackle 900 papers and make my way through it. Now then, for these 56 papers from 2023, I have a question framework, which I apply to all of the papers. I'm going to run you through it because it's somewhat important, but bear with me. The first question was what research problem from the legal field is the research subject of the paper? Then I asked some questions that relate to the disciplinarity, cross-disciplinarity, or nature of where the authors are from. One of the questions was the jurisdiction of both the author and the research subject, which seemed to align in most of the cases, so nobody is solving problems that they are not having themselves, pushing ideas there. I looked at, in order to make this computer science versus law discipline, what is the professional or academic discipline of the authors? Again, because this research is a quantitative method, I had to make a reduction to this, and sometimes this is very difficult. On the one hand, you might label a first-year PhD student who just has a master's degree in law as a lawyer, whereas someone who has been doing both for the entire career as a professor in this AI and law field, you have to pick one in the end, like what is their degree or what is their identified profession. It was a reduction, but I thought it was worthwhile in order to make this interdisciplinary, cross-disciplinary question. Then, of course, what the motivation or urgency of the authors was to do this research, to write the paper, to create the deliverables, and finally, what type of research is being performed. So getting to these terms that I defined, the technology push or the question pool, what were they doing? Now to the results. A whole bunch of work, a couple of months, 900 papers reduced to one slide with 4 numbers, where I hope I now have most of you online of what all of these words mean. So in this corpus of contemporary legal informatics, the Journal of AI and Law, ICAL and Jurix, in 2023, 39% of the papers were about a code-driven topic. The rest of it was about data-driven methods. 60% of the papers I labeled as having a technology push, that were primarily pushing forward a new technology or idea from technology. 44% had a clear legal question up front, and that may need it in some cases, some new technology to be created, but the overlap was incredibly small. And in terms of the cross-disciplinarity, 52% of the papers in this data set had at least one author from either the CS or the law label. So what does this mean? Let me get back to the original questions or hypothesis that I posed. Is legal informatics no longer a cross-disciplinary research field? Some reflections on the and position papers and celebrations of the field have wondered this as well. I've quantified this, and yeah, it remains cross-disciplinary. We get the 52% mark. It's over half, but it's very much dominated by computer science. Then the second question. Are we missing valuable contributions from legal informatics, both for the human critical problems or the socio-technical problems that we've seen in different presentation, and in terms of understanding the underlying normativity? Yeah, maybe. I think the communities are not always very inviting for lawyers and computer science to sit together to really engage on the topics and the subjects, and to not forget about the most interesting things in each other's work and in their own work when working together. Fortunately, there are new outlets, much like ProLaLa, where there's a programming language community that is explicitly in the design and the question call very open to say, hey, we're not doing just technical stuff. we're doing technical stuff, but that is really related to the law. And the CRC journal, for which, or the Circle journal, for which I also work, we explicitly always have a replier from the other field, whether it's being computer science or law, write a response to the papers that we publish in the journal. So there's always an inherent interaction, no matter what the technical depth in the contributions is that people from either field would be making. And of course, the question like, are people really more interested in these communities in pushing technology forward? Is this more important than solving actual legal or legal administration problems? I would say yes. There is very clear preference for this technology push, and noticeably little intention to question pool. From time to time, this was also about the sort of second order idea that there was a toy example once, long time ago, in a paper that we quote, and then it's almost forgotten that the work is still in a legal discipline. So what to do with this? I have one recommendation, and mainly this is to make anyone who would want to do my research in the future simpler. Explicitly have these keywords in our work and our contributions, just to make it noticeable, but also to sort of remind ourselves in these communities, especially these new outlets like ProLaLa, that we shouldn't make the same mistakes that have been made in the same traps that, that people encountered in the traditional legal informatics communities. Notice that you're really talking about normativity. When we talk about the tax law, and especially implementations, coded implementations of the tax law, make sure that we know that that this is having a legal effect, that is creating a legal effect, and especially if the technology, the code, is the first thing that people run into. Be aware of the cross-disciplinary market, see in the different papers and the collaborations and the programs, where are we actually coming together. Be wary for the question pool. Seek opportunities and define the questions that you come across. Maybe someone else can solve it and make the contributions. And also be wary and give notice to where the technology push exists. I think in computer science, we're all excited about creating this new technology and these new opportunities. But also be aware that if we get too excited and too focused on just the new innovations, just the new things we can create, just the engineering or just the puzzles we can solve, then that is not what legal informatics might be about. And I think if we just be explicit about these words, then I think we don't necessarily have to change from one day to another, but at least create opportunities to have a very explicit and clear debate about the subjects and the topics that I mentioned today. Thanks for your attention. Please get in touch if you have any questions about this subject. And I would like to thank Professor Hildebrand, Professor Geuvers, Dr. Merigou, and the people at the Computational Machine Ethics Workshop for early discussions and contributions on the work that I've done. Thank you.
All right. Okay, pleasure to be here. So today I'm going to be talking about some work that we've been doing with Raphaël Mona and our PhD student, Pierre Goutani, as part of the Avocat project. And so Avocat actually means lawyer in French, but it sounds a lot like avocado cat in English, hence the logo. So, to give you a bit of context, let's consider some computer implementation of a computational law. Think, for instance, of something that computes your taxes, that determines whether you're eligible to social benefits. So you have this program. The question is, how do you ensure first of all, that the program itself doesn't crash. So for instance, that you're not going to have any division by 0 during the execution of your program. How do you ensure that the law it implements doesn't have any inconsistencies or unhandled cases which might prevent it from being applied in some cases? And additionally, how do you ensure that the law, the code you are implementing, actually match the legal statutes? So how do you ensure you have some equivalence between the code and the legal statutes? So these kinds of questions are things that we are used to working on in computer science, especially in program analysis and formal verification. And so a natural question for us was, is there a way to apply formal verification techniques we are used to this kind of application domains? So if you see the first two properties as some kind of safety property and the last one as some kind of functional correctness property, can you apply existing techniques and tools to this? Formal verification is quite a large field, so let's try to scope a bit more the requirements, what we expect of formal verification tools applied to the law. So the first thing is we want tools to be expressive enough to be able to reason about the structure of the law. So what this means is you want to have some reasoning about the base case and exception structure that commonly appears in legal statutes. The second thing is the kind of tools we are developing will be used both by computer scientists that are not necessarily formal verification experts, but also, and more importantly, by lawyers. So you want to make sure that these tools do not require any expert knowledge of verification, and in particular, you would like them to be as automated as possible. And lastly, it's not enough to have a tool that says, oh yeah, your program is great. You also want the tool to generate actionable examples or counterexamples when you have an issue. Because you want, first of all, the programmer to be able to debug their code, but also lawyers to be able to go into the text, into a legal statute, and compare it with the example you're providing to determine whether the law itself is a problem or whether the program is inconsistent with respect to the law. And so, one possible solution we've been exploring, and that I'm going to talk about today, is concolic execution. So I'm not going to go too deep into the technical details, but to give you a glimpse of how this approach works, let me explain what concolic execution is on a very small and simple example program. So in this program, it's doing something very basic. You just assume you have two variables, x and y. And so if x is greater than 0, you return 0. Otherwise, if y is smaller than 10, you return 1, and otherwise, you might have an error. So how would concolic execution work here? Well, you would start with some concrete inputs, here picked arbitrarily to be x equals 5 and y equals 5. So you would execute your program with these inputs, and while executing the program, you would collect what we call symbolic constraints, which capture the execution path that we are currently taking. So in this case, what this is saying is, all the inputs that have x greater than 0 would take the same execution path. So here, on the top right, you have an execution tree which represents the possible execution path of the program we have been exploring. So once you have this, you would like to explore a different execution path, and so you would like to generate inputs taking a different path. How to do that? We're going to rely on automated constraint solvers called SMT solvers, and query them with a negation of part of the path condition that led to this execution path. So in this case here, we would query the solver with a constraint not x is greater than 0, and the solver would generate some new inputs, for instance, x equals 0 and y equals 5. You would execute the program again, collect symbolic constraints again, and get a new execution path. So here in this case, not x is greater than 0 and y is smaller than 10. And so repeating this again, you query the solver with a negation of parts of a path condition, you generate new inputs, you run your program again with these new inputs, and now suddenly you explored all the possible behaviors of the program. And so what does this give you? First of all, this gives you a set of test cases which tests all the possible execution paths of a program. And second, this does it in a way that avoids redundant test cases, in the sense that you only have one test case per possible execution of a program. So this is the core idea of concolic execution. That's something that's been pretty well studied in standard program analysis. And so in this work, we've especially been applying it to the ProLaLa domain-specific language that some people before me already presented. So the core idea of ProLaLa is that to match the structure of a law, it relies on some structure which implements prioritized default logic. And so the core technical part of the approach, which I'm not going to talk about too much today, was how do you concolically execute default logic. And so we provided an encoding that allows you to do that. We implemented it in a tool that's called CuteCat, and we now have a concurrent execution tool for Catalan. So to make it work, we also have several heuristics, especially for the performance of the analysis, so to try to prune test cases that might be redundant, and also for usability, especially to generate inputs that are a bit more readable and a bit more usable by users of a tool. So what CuteCat allows you to do is to test different execution paths in Catalan programs, and it's particularly geared towards detecting ambiguities in the program, unhandled cases, and also possible crashes, meaning, for instance, possible divisions by zero in the program. And so we've been experimenting with CuteCat on the existing Catalan programs. And on most programs, most Catalan programs are pretty small, so you can have answers in a few seconds. But the interesting one was the biggest Catalan program up to date, which is an implementation of the French housing benefits, which totals around 20,000 lines of Catalan programs. And so we could see that our tool managed to scale to this and to generate almost 200,000 test cases in close to 7 hours, which gives you a great coverage of all the possible cases for the French housing benefits. So there is just one heuristic I would like to talk about today, which is the one about doing human-readable test cases. So to give you a very toy example, let's assume that you have a part of a law that discriminates based on some income. And so this is going to be framed as saying, well, if the income of this household is strictly greater than $20,000, then do something else, do something else. And the specifics are not really important here. So if we apply our tool to this might generate these two test cases, saying, well, in one case, the income is $20,000. In the other case, the income is $20,000 and 1 cent, which indeed is strictly greater than $20,000. Now, unfortunately, if you want to redo computations by hand, that's a bit of a pain because you don't want to handle cents and rounding and all of that. So if the only thing you want is to have something greater than 20,000, you would much rather have, say, an income of 21,000 and redo your computations with something like this. So that's something that we are providing in CuteCat using a feature called soft constraints. And so the idea of soft constraints is that you can add preferences, you can add constraints when generating inputs, which are not a priority compared to the actual path condition and to the actual logical query. And so in this case, that means that if you can find an input that says doesn't have any cent, that's the one that's going to be generated. Otherwise, you're still going to get an input. It's not going to be ideal, but at least that's one input to generate this test, to execute this test case. And so the important part is right now, we are especially targeting this for this kind of monetary inputs, but this is a more general framework where the specifics of which kind of test cases you want can be specified by users directly and especially by lawyers, depending on application domains. So to conclude, today I quickly presented a new concurrent execution tool for Catalan called CuteCat. And so the main job of CuteCat is to generate many test cases experimenting with different execution paths in Catalan, and especially aiming to detect ambiguities and unhandled cases in Catalan programs. This is something that is already integrated with the Catalan build system, which means if you do have a Catalan program, it's super easy to just run the tool on it and try to generate test cases and find ambiguities. And so the main question I have for the audience today is, we can detect ambiguities, we can detect unhandled cases. What would be the other interesting properties that we would like to reason about and that we would like to help lawyers with? And with that, I want to thank you for your attention.
So we still have that problem, right? That the law is in text form. So how do we ensure equivalence?
Right. So you're meaning how do you ensure the functional correctness with a law text?
Oh yeah.
Yeah. So that's still a tricky issue. So the main idea of Catalan is that by having a language that is closer to the structure of a law, you can have these peer programming sessions between lawyers and computer scientists so that you can stay as close as possible and not have a computer scientist interpreting the law. There is still a mismatch here. And the issue becomes that you don't have a logical specification, you only have a textual specification, so it's hard to reason about this. But yeah, at least the idea here is if you have something that appears to be an issue in the program itself, you can generate concrete test cases and get a lawyer and a programmer in the room together and trying to understand precisely where there is a mismatch.
I'm just improvising here, but see, so LLMs can do interpretation in the usually imperative language is better. So can we do equivalence with Katara, this DSL, and then sort of ensure correctness there? But of course, there's no confidence there.
To be sure I understand the question, are you saying can we prove equivalence between the text and the code with LLMs?
No. So I was just thinking that we can ensure equivalence between Katara and a Java program. And then LLMs would find it much easier to convert this text to Java, for instance. But again, there is still tricky. No guarantees still, right?
Yeah, I mean, I think you can. I think the main question is, would you trust the LLM's output, and how would you explain the LLM's output? But I think that's an interesting direction for sure. It's a bit unclear at the moment whether it could replace a human in the loop.
Hi, Emeric. Thanks for the talk. I was curious about kind of the harnessing. So to do dynamic symbolic execution, you need a harness. Is that something that's automatically provided, or is that something that is like it's part of your project?
So that's one of the things we would like to explore. So basically, to do this kind of analysis, you only need one initial test case. And then once you have the initial test case, you can compute new examples by exploring different execution paths. One very interesting avenue we intend to explore is, let's take an existing system. It likely already has its existing test harness. Can you adapt it, and can you avoid redoing some of the work so that you keep the existing tests that some administrations might have? That's something that we haven't explored yet. There are some technical reasons behind it, and I'd be happy to talk to you offline about it. But yeah, that's an interesting question.
We have a discussant who is not in the room at the moment, so I'm happy to continue with the questions for now for Emeric or for any of the presenters.
Hello? Okay. Great question. I don't know if we noticed an issue specifically with the fact that the LLM reasons forward, because typically what we would do is we would feed in like the statute, like the whole statute, and then be like, translate this, to whatever language. And you can do that in the literate programming style of Katala, of like, translate this to like Markdown with Katala blocks in between, or you could just say like, translate it directly to Dagger, for instance. I don't think that's the issue. I think the issue is more like, if you tell the LLM like, here's the statute, translate it to code, and then you're like, now here's some test cases, translate those to code, then you run into issues if it doesn't know exactly what the kind of form the test cases are going to take, right? So like this is something we ran into with Katala, where like even just as humans, we wrote it, we like translated it to Katala, And then we tried to translate the SARA like test cases, and we found that it was challenging, and so we had to go and rewrite it. And because we struggle with it as humans, we'd expect LLMs would have a similar difficulty, and that was what we found. I don't know if that answers your question.
Hello. Yeah. I think I also have a question for you, Sam, because when I looked at the Katala programming language a while back, one of the great features is that it allowed for literate programming. That is a design feature, but also the success it had, the beautiful things that it did was Denis and his lawyer companions actually programming this out. So the magic for me was in the pair programming, in getting the same people in the same room, which of course is the theme of what I've been trying to tell in my presentation. How do you feel the LLM fits in the chemistry of pair programming or extreme programming? Are you replacing the programmer? Are you replacing the lawyer? Are you replacing both, or just playing, seeing what happens? Thank you.
Yeah, I don't think I have a super clear answer to this. Probably Rohan has a more reasoned answer to this. I think that there could be like a dream that's like probably way too naive, which is like replace both. I don't think anyone in this room actually believe that's going to work, but it was kind of just like an early stage experiment. Like, I think that one thing that we like, because we don't have any law experience, like Vasu or I, we weren't able to appreciate, I think, enough like a lot of the syntactic choices in Katala to make it like more amenable to the language, like the kinds of words that lawyers use that like computer scientists don't really use as much. So we just like, kind of like got rid of all that and replaced it with like CS like terminology, which I don't think would really support the pair programming use case very well. And that was just like a limitation of our experimentation process. I don't know if that answers your question at all.
Yeah. Thanks.
Our afternoon session at 2 for Charles Duan's tutorial. See you all after lunch.
Transition.
You are streaming right now. Stop. Don't do that. Go to break. Back to break. Back to break.
Charles, can you say something?
Yeah. Still hear me? Can you still hear me?
Yes, we can hear you. So, can you share your slides?
Okay. Yes, I am figuring out how to share the slides right now. I don't know where the slides went. Oh, because they are in the same. They can't be in the same browser as the Discord. Just share the entire screen. Okay. Okay. First of all, let me join the correct channel. Hey, why is it not sharing my screen? All right, close enough. It's still not sharing my screen, is it?
No, it's not.
Okay, I don't know why we're having a problem with this. I said allow.
You were able to share it before, right? Is that button to share screen?
I was, but that was on a different computer.
Oh.
Oh, do I have to not? Maybe I have to stop sharing on the other computer? No, the
Yeah,
other one is no longer
maybe.
sharing.
I don't think you're sharing.
I don't know why it's.
It should be the same button, like in the bottom left.
Yeah, and I keep hitting it, and I say share the screen, and I choose the window, and it does not work.
Can you just try sharing the desktop, the entire desktop?
Yeah, I've tried both. I've tried both.
Is it some Mac permissions thing?
That's a good question. Where would the permissions be? Privacy and security. To work?
Okay, yeah, we see your entire screen now.
Okay. You see slides?
Yep, we're good.
Okay. This is. Let me pull up my notes on another computer. Okay. Are we live?
We are live with Charles Duan talking about legal citation.
So I have like zero sense of what the audience looks like. And I can also really hear myself, which is kind of strange.
Yeah, we can all hear you. You can open the YouTube live stream if you want to see what the audience is like, but we can't give you a direct feed, unfortunately.
Okay. The sound is very much echoing back to me.
Is there any way that we can turn that off? Otherwise, I'll just take the headphones off while I'm presenting. Wait, I think it's better.
Should be good now.
Okay. All right. Get started. Thanks so much for your patience, and thanks everybody for helping out with the AV issues. I really apologize for all of this confusion. And also thanks to James and to the organizers of this conference for inviting me to talk about this. So this is a project that I have been working on basically ever since I was in law school, on developing a computer program that did my legal citations. And so this is something that I've been using for a long time. And as I've been working on it, I think that the insight that I've developed is that legal citations are actually more complicated than I expect, and that's not just because the Blue Book makes it so. And so what I want to do is share a little bit of those insights with you today by thinking about legal citations as the title suggests, as a programming language. Now, we all know that legal citation is extremely weird. This is just a random page from the famous case, as in the rule in Shelley's case, from Sir Edward Cook's reports, and you can see the citations
Child,
there. It's
really,
just a bunch of numbers.
Sorry, Charles, really quick.
Yeah.
For us, we only see the first slide right now.
You still see the first slide?
Yeah.
Okay, do you see slides moving around?
No, I think we might have seen your mouse, but...
No. Okay, let me try doing it, not full screen. Does this help? Okay, so what do you see now?
We're still on the first slide, but we also see your Discord. Oh, sorry. Give us 1 sec. Give us 1 sec. Okay. Yeah. Now we see slide 2, I think.
Okay, the one that's got like some old text.
Yep.
Okay, now let me ask you this: if I present, do you now see that same slide?
Yes.
Okay. If I move to the next slide, do you see the next slide?
Yeah. Yep.
Okay. I'll hopefully it's working at this point.
Yeah, I think it was.
Okay. So. All right. So as I was saying, this is a very old version of legal citation from about the 16th century. And number one, you can see it uses a ton of abbreviations. It uses all of this Latin. It seems very obscure. And so you would think that after 400 years, maybe we've gotten a little bit better, but no, we haven't. Here is a contemporary piece. This is actually something that I wrote myself. And you can again see that there's all sorts of fonts. There are a lot of abbreviations. It tends to look very imposing, I think. And before I was a lawyer, I often wondered what is going on with these legal citations. It seemed to be the sort of mysterious code, possibly what people who are programmers look at computer programs like. And so this has obviously been the system of legal citation, besides just being sort of weirdly archaic, has been heavily criticized over many years. It's been called overly complex. It's been called arcane. Every once in a while, somebody will write a law review article, basically making fun of the updates to the legal citation system, and primarily the key manual for it, the Blue Book. So there are a number of articles titled "An Uninformed System of Citation," or "The Blue Book Blues," or "The Folly of the Embedded Full Citation," or "Oh no, yet another revision to the Blue Book." Besides this criticism, there's also pretty good evidence that the whole system is just very wasteful. Wasteful of time, wasteful of money, and wasteful of intellect, in a sense. Editors at law schools, so student editors who review journal articles, spend most of their time making sure that the citation formats are correct and arguing over whether commas should be going before or after the quotation marks. Paralegals charge hundreds of dollars an hour, basically doing the same thing, making sure that the formatting of citations are correct. There have been plenty of attempts to try to address this problem. Students at the University of Chicago put together an alternative system of citation, the what they call the Maroon Book. The Association of Legal Writing Directors, or ALWOD, created a competing legal citation manual called the ALWOD Manual. And then there are also attempts at automating the whole process. So we have a number of citation managers, Zotero, Jurasem, Mendeley, and EndNote, who all implement various forms of legal citation compatibility, basically things that are like BibTeX for legal citations. All of these exist. Very few of them have really succeeded. The Chicago Manual, the Maroon Book, which Judge Potter praised as this paragon of conciseness at its origin, I think it was only 15 pages long, has now ballooned to over 120 pages of citation manual. The ALWOD Manual, the same thing. And all of the automated citation systems that I mentioned here are generally understood to be a pretty good first cut, but not a perfect solution, and they all say you have to go back and manually edit your citations before you're able to submit. So what's going on here? Why do we have this very complicated system that has so far seemingly defied any sort of automation or systematization or attempts at simplification? I'm going to argue that the fundamental problem, not just inertia, which one we might think of, or not just unusually detailed rules that the Blue Book has, but actually a conceptual problem that we need to basically better understand what legal citation is. Regular citation systems, like in computer science or in the humanities or other areas, are fundamentally pointers to authority. Cite something to tell somebody this proposition is supported by this reference. And as a result, we have lots and lots of really good systems for doing this. Legal citation, on the other hand, does a lot more than simply point. It, in fact, I'm going to argue, is an entire language and allows for people to be expressive and argumentative purely through the citation system. And as a result, if we're going to try to improve the state of legal citation today, either by automating it, by developing automated automated citation tools, or by trying to improve the system through better manuals, education, or simplification of the system, we have to understand how the system works as a language. We have to see what its purposes are, what affordances it provides in order to achieve those purposes. And from that understanding, we might have a shot at actually building something that really addresses the complexity of legal citation. In a sense, this talk is just a tutorial on the system that I built to do this. This is a program called Here and After. You can access it on GitHub. I've been meaning to put it on CTAN. So this is a LaTeX package that I put together over the last couple of years, as I mentioned. And so in a sense, this is just a talk about how the system works. But I think it actually goes a little bit further than that. Because the broader story is that it's an investigation into the grammar and the structure of the legal system as I've discerned it through my work in putting this together. And I hope that some of the lessons that I've learned and some of these broader ideas can help us basically gain a better understanding of legal citation overall beyond this one particular program that I've developed. All right, so let's get into it. First of all, I mentioned that legal citation seems like this language. It seems like much more than simply a way of pointing people to authority. So what are those things that it does? Well, so legal citation certainly does point people to authorities. You use a citation to support propositions, and that's probably the primary purpose of a legal citation. But you can also do a lot of other things. You can highlight a debate among scholars or among courts. You can cite several different cases, for example, in a single citation, and say, hey, this case is on one side and this other case is on another side, and you can explain to people there is a debate going on simply within the citation system. You can use citations to impress your readers. A lot of times when you open up a law review article on the second, third page, the entire thing will be filled with citations. What impression do you get from that? You're looking at that and you're saying, wow, this person must have really researched this subject, or they must be really knowledgeable, or they must really like showing off because they filled their entire page with citations. But in that sense, the citation page is serving a communicative function that goes beyond simply pointing people to authority. You can also use citations to identify the authoritativeness of the things that you're citing. In law, we spend a lot of time thinking not just about what people say, but about who said it. One court is not the same as another court. If the Supreme Court said something, it's different from just like a trial court saying that. And the ability of the citation system to easily convey who the speaker is and the speaker's authority is a pretty important feature of a legal citation system. You can also use citations to show historical development. Often what you can do is you can trace the entire history of a legal doctrine or a line of argument, possibly through centuries, simply by listing the citations with their dates. And in fact, one of the rules that we have in legal citation is that you should present things in a certain chronological order, all other things being equal, in order to show that sort of historical development. Citations often are also used not just to support things with authority, but also to criticize and distinguish authority. You might cite a reference in order to say this reference is problematic, or this reference actually shows that there's a debate, or I disagree with this reference. And there are ways of indicating that disagreement through the citation system itself. You can also use it to celebrate people's scholarship by identifying the names of authors or by identifying articles in ways that tend to promote it. This is kind of the opposite of the criticizing function. So legal citation serves all of these functions. Now, of course, in any sort of literature, you can do all of this. Nothing stops you from highlighting a debate in computer science by simply citing a bunch of works and talking about the debate. What I'm saying here, though, is that you can achieve these functions purely within the citation system itself, simply within a single citation without external text. You can actually do all of these things. And these are the sorts of expressive functions that I find within legal citation that I think make the system very unique, and make it sort of explain why it requires a lot of this complexity. Let me show you let me show you an example of this. So this is another piece that that I took for my own writing. Here you see we've got so this is in the context of a discussion about some court decisions on how computer programs work and how they function with regard to computers, with regard to computer hardware. And so prior to the quote that I'm reading here, I quoted another part of a case. And what I'm going to do now is I'm going to disagree with what the court says. And so I have some text that explains my points of disagreement. But then I'm going to use the citations, the legal citation system to highlight exactly how I disagree and how I believe that disagreement has played out. So you'll start out by seeing that CF thing, right? That's what we call a signal. That introduces the citation and tells you what I'm using the citation for. Ordinarily, if I just said nothing, or if I said C, if my signal was C, that would be like, okay, if you want support for this proposition that I've given you, see this reference. CF, compare in Latin, means that thing that I just said, compare it to this thing. And that means I'm going to tell you something kind of interesting about the citation that might make you think further about what was just said. So the signal there indicates that I'm about to have a conversation with you that goes beyond simply what the citation is all about. We then have the name of the case. We have an identifier. So the case is named Alapad. We have an identifier, that 33 F3rd at at 1566, you can treat that basically as a document identifier. That's what allows you to go look up the case. Then we have this parenthetical, parenthesis Archer C.J. dissenting. That's what we call a parenthetical. We attach those to the ends of citations in order to give more information about the thing being cited. And here we learn a couple of very interesting things about the thing I'm citing. Number one, we learn that the person who's speaking in the part that I want to reference is the chief judge of a court who's named Archer. So the CJ tells you about the weight of authority. It tells you that this person's a chief judge, probably a pretty important person. It also tells you that this person is dissenting from the rest of the opinion. So at this point now we have a pretty good sense of what the authority of the thing being said is. We can then follow a second parenthetical that provides a quote from the original source, and that provides basically argumentation as to why I'm using the reference. And so that just kind of adds to the value of the citation as not just a pointer to authority, but as a point of argumentation. We then have a semicolon, a second citation, and another parenthetical that again gives some more information about basically my points of disagreement with the case. So you can see that this citation is not simply pointing people to authority, it is pointing people to authority. It is pointing the reader to, if you want to see my reasons for disagreement, here are all of the people who have agreed with my point of disagreement. But it's also saying, this is the weight of authority that it carries. These are the types of people who are saying it, and here is exactly where I think they have made the arguments that you should be looking at. And in general, here are a couple of the features of legal citations that I think get us to the point of legal citation serving all of these expressive and communicative purposes. So number one, signals, I just talked about those. Those are the things that say, this is why I'm citing something. You put that in front of the citation. Those parentheticals that I just mentioned, they can give more information. They can give further argument through quotes or through description. Embedded citations are a very interesting feature of legal citation that I don't think I've seen anywhere else. You can cite something and then inside a parenthetical cite something else, basically saying, here's an authority that quotes another authority and cite the thing that's being quoted. Basically, you do that to further enhance the believability of the thing that you're citing, because it's like, not only do I have this great authority to support the thing I'm saying, but they were quoting from another great authority. So you can use sort of embedding of citations and multiple layers of citations to further strengthen an argument. Similarly, you can use references that connect. You can say, here is a thing that I want to cite, and it was quoted in all of these other things. And that just, again, is useful to enhance the weight of authority of something that you're citing. You could say, not only am I quoting this, but here are a bunch of other really famous people who quoted it. You should really believe this. A couple of other interesting sort of affordances that I identify in legal citation, the way that we talk about authors. In general, for most disciplines, authors are authors, and we just say, you identify the authors by name. In law, though, we care a lot about the institutions that authors are affiliated with. And as a result, legal citation systems provide fairly complex rules for attaching institution names to human authors. And one of the problems, actually, is that the ways in which these are structured have been kind of underspecified. And so one of the problems that I've had to deal with developing my software is figuring out what's sort of the grammar of specifying authors when you have both human authors and institutional authors. That's been a problem that I've had to spend some time thinking about. And finally, there's a fairly complex grammar of page numbers and dates because of the fact that those are important features of legal citations. You have to know when something was said. You have to know exactly where on the page something was said, because a lot of these law review articles run run like 100 pages long. And as a result, all of these sorts of things have to be specified within a legal citation system in order for the citation system really to serve all of the communicative functions that lawyers hope to take advantage of and that law scholars hope to take advantage of. So that's kind of the first sort of like major premise of developing a legal citation system that I think is important. The idea that there are many purposes that the citation system serves, and as a result, we have to think about a lot of different affordances that the system should provide us, such as the ones I've just listed. Here's the second big premise. In the legal citation system, we have people who write and we have people who read. Now, this is, of course, true about any sort of citation system, but I think it's particularly pertinent for law because we spend a lot of time thinking about writers and about different types of readers because we have lots of different audiences that we're speaking to in law. We have judges, we have law scholars, we have practitioners and such. And the things that they need out of legal citation are different between readers and writers. Readers, what they're looking for are fast visual cues and clear conventions that provide all of that information that I just talked about. Be able to tell that something is from a court versus from a law journal versus from a statute very quickly, because that helps you assess whether or not something carries a lot of authority as you're reading. And that's why we spend a lot of time using like small caps in legal citations. That's why we use all of these parentheticals, because they provide those fast visual cues for identifying what an authority is, who the speaker is, what its purpose is within a piece of writing. At the same time, if we were to fully describe every single thing that is being cited, law review articles would get only longer because a lot of those titles of articles are very long. And as a result, we take advantage of a lot of abbreviations. Readers want abbreviations because they make sure that there isn't that the page doesn't get too full. Abbreviations, though, require a piece of writing to be stateful. As you read through the article, the first time you present a citation, you give a full citation. You provide all the bibliographic information. The second, third, fourth time, you'll use a shortened form. Sometimes we'll just use an id or an ibid in order to save as much space as possible. Again, this is basically for convenience of readers so that they don't have to see the same large string of text multiple times in a row. Writers, on the other hand, as they're writing documents, I think are looking for something somewhat different. Number one, they want things to be easy to write. Every time I want to write a citation, I don't want to spend a lot of time going back to the manual looking up whether or not I'm supposed to use small caps or italics in a place. I want to just be able to type things quickly. I also want flexibility in the order of my work as I'm writing. If I decide that I'm really on a roll typing, I just want to be able to type. I don't want to have to stop and go and look up a source and find all the bibliographic information. Maybe I want to be able to save that for later, right? That's one of the things that I always really liked about systems like BibTeX. You could just put in citation commands into a document. Without actually filling in what the citation is for, you would compile it, you get an error, but then you can go back and you can fill that in later. So you can adjust your workflow. So you don't have to adjust your workflow based on the citation system. The citation system can work with your workflow. The third thing, and I think the most important thing that I would want as a writer in a citation system is statelessness. As I'm editing, I might decide that, I've written section 1 and I've written section 2. I think that section 2 is in the wrong place. It should go before section 1. So I just want to be able to copy section 2 right above section 1. If I'm working with a document that is full of stateful citations, that has lots of id and supra and lots of cross-references, when I copy those citations over from one place to another, everything is broken. You end up with something that looks like this. This is not real, but this is what a lot of my articles used to look like. You end up with these blanks and fill in things and reminders and question marks. And the reason that people write like this, including myself, is that in a system of citation that's designed for readers, where we do a full citation first and then we go down and down using short citations. If I want to be able to edit the document, I need to come up with essentially my own sorts of conventions for how I want to write. And those end up being essentially ad hoc and idiosyncratic to the writer. So what I'm hoping to do, sorry, so what I'm hoping to do with my program, with my citation program, is essentially develop a language for writers of legal citations. Basically, come up with a convenient way of writing out citations during the writing process that an automated computer program can then translate into the proper formatted legal citations that are more convenient for readers. This is just like what any of the other sort of automated legal citation, or what any of the other non-legal citation systems do. It have to adapt it to this much more complex grammar and set of affordances that legal citations provides us. So let's talk about what that grammar looks like. Let's look at what legal citation looks like when we try to break it down as if it were a sort of programming language, as if it had a grammatical structure. The first thing we do is we break them down in the same way that other citation systems do. We have citations and we have references. So anybody who's worked with a citation management system will be familiar with this. The references are the individual works that you're citing. You enter them, you give them nicknames, and you provide bibliographic information for them through sort of like a key value format. And that defines all of the things that you can cite, all of the documents that you might want to cite throughout your document. In hereinafter, there is a little bit more complexity to the references, mostly because you end up with some situations with legal documents where you can have a document inside another document, and there are certain special ways in which I need to deal with that. But generally, references are defined in a way that's very similar to how how any other citation management system would do it, by providing metadata for individual documents. It's really the citations, the places in your document where you refer to the references so that information about the references is inserted, where a lot of the magic happens, because we have to add in ways of talking about the parentheticals, the signals, the page numbers, and all of the other sorts of information that I mentioned are included in legal citations. We could do this, but we could do this by just having a bunch of commands that do each of those. But one of the things that I found is that ends up just becoming so verbose that it becomes almost too time consuming to actually write out citations, particularly if you want to write out a fairly long citation. And so what I instead have developed is a domain specific language for specifying the content of a legal citation. There are two components to that domain-specific language. The first is that there are several different types of legal citations. Broadly speaking, you can cite something in text as part of a sentence, or you can cite something separate from the text as its own independent sentence or clause, set apart from the rest of the text. And so all of this is in tech. So I provide a number of commands that allow you to do both of those. The commands inline and adjective, those allow for making citations that fall within a sentence. The difference between inline and adjective is that every once in a while you have a reference that starts with the word the. And so if you use it in an adjective context, you want to take the word the out. And then I also provide two commands for non-sentence, non-inline citations. Those are the sentence and clause commands. And so the example here, you can see both of those at work. You first see inline bracket Brown was decided in 1954. So that's going to put the name of the case, Brown versus Board of Education, as if it were a noun within the sentence. So you see that generates Brown versus Board of Education was decided in 1954. That's followed in the code by \sentence C Brown. And so that translates through the program into a citation that follows the sentence. You see the italicized C, that's the signal again, and then 347 US 483, that's the document identifier, and a parenthetical for the year. One thing you might notice is that in the citation in the sentence form citation, the name of the case, Brown versus Board of Education, has been automatically omitted because that tends to be the convention in legal writing, that if you've already identified a case name, it's omitted from the. If you've already identified a case name in text in an inline form, you omit it from the citation form. And so one of the nice things about doing this by computer program is that that can be done automatically. Okay, so these are your two sort of broad categories of ways of using citations within a document. The thing between the braces is a specification of what you want to cite. And now we can talk about the grammar of that. So within those braces, you put a thing called a citation string. And a citation string is one or more citations that are separated by semicolons. And so the idea is that this is supposed to be a series of things that you want to cite. A citation then is composed of a number of elements. First of all, it has a signal. And so I've given a couple of examples of signals here. So e.g. C also. You prepend that at the beginning of your text with a citation string. You can then optionally provide a volume number to the extent that your reference is multi-volume. This is mostly useful for books. You then provide the reference name, so that would be the nickname of the reference that you want to cite, and then you provide information about the page number. Actually, that's a mistake. That should be the at page should be optional, because you can omit the page number if you'd like, and then finally you follow that with a number of parentheticals. Parentheticals are worth about just a little bit more in detail, because there are a couple of different ways in which parentheticals show up in legal citations. One of them, of course, is just parentheses and a bunch of text, and you can, of course, do that. That's the second alternative given in the grammar here. But the first alternative is where you want to refer to another work that's related. If your work is quoting another work or is quoted in another work. What you can do here is in here and after is you can provide the relationship, that's the related grammatical element. Those are typically going to be words that end with, quoted in, or cited in, or discussed in, or ing verbs such as quoting, or discussing, or contradicting, or something like that. And then you provide another citation string within the parenthetical, and that automatically creates an embedded citation, or basically a number of citations in sequence. And so again, that allows you to have that conversation among references where you're saying, here is one reference, and that reference was quoted in this other reference, and maybe it was followed up by this other reference, and you can tell an entire story just through using this sort of parenthetical form of multiple citations. So here are a couple of examples of how that works. So here I've got, got a definition of a case. This is Wheaton versus Peters. And so you can see, like other bibliographic reference systems, we've got a couple of pieces of metadata that define the elements of this Wheaton versus Peters case, its identifier, the party names. And then you have sentence brace Wheaton at 602-603. That Wheaton at 602-603, that's the specification for the citation that follows that domain-specific language that I just talked about. And then here and after, we'll automatically compile that and convert that to the formatted citation that's below. This is just talking. So one thing that I provide is a slightly simplified way of entering references, because often you type in cases, it gets a little tedious to type in all of the parameters for cases. And I can talk a little more about sort of the entry of references, if that's of interest to anybody. Here's a more complicated example, and I hope that this shows kind of some of the key features of the citation system. So number one, you can see within this sentence, the citation string contains a number of different elements. Those are separated by semicolons. You can see citations to cases. You can see parentheticals like the stating case parenthetical or proposing theory parenthetical. You can see signals, the word C that's used in a number of the citations that allows you to insert that. And then you can also see this parenthetical citing : Wheaton at 688. That, again, is this embedded citation idea that allows you to say how one reference talks about another reference. And as you can see, all of that is automatically converted into appropriate formatting for legal citations in the examples below. Now, I mentioned that the really important thing about the system is statelessness, is the idea that you can move parts of text around without having to worry about your citations going all awry. And here's an example of how that works. So what I did here is I took, in the previous example, you see I had two sentence commands, one of which was much longer and the other which was shorter. Here I've switched them around. They're otherwise the same, and I didn't change anything string in the stuff between the braces. I just copy and pasted them. But you can see that the citations that are generated are fairly different at this point. You see id citations, and you see a short citation to the Banks case in the second longer string of citations, whereas in the previous example, it had to use a full citation to that because that was the first time we talked about the Banks case. And so this is really sort of the power of the system, that it allows you to easily move things around without having to deal with the problem of rewriting your citations. And yet it also captures, at least I hope, much of the flexibility and the power of the expressive functions of the legal citation system. And I think that that combination of these two things really has made this a very powerful system, at least for me. And I think has been really instrumental to my legal writing over the years. What are some things that I think are potential future work that come out of this thing? So number one, statutes. Statutes are very complicated as documents. I'm not totally sure how to think about them. Second of all, there are lots of forms, there are lots of types of documents for which I don't have predefined citation formats, and it's fairly hard to define new ones. And I think a big part of the project will be thinking about ways of making sure that there are people other than me who can expand the system. Compatibility with other systems is something I've been thinking about. I would like to easily be able to take a Blue Book formatted article and convert that to Chicago format or to Oscola format or to some other legal system. I would also like it to be easily convertible to BibTeX or to some other systems. I have ways of doing that right now, but they feel rudimentary and somewhat hackish, and I think that there are ways of improving that. The holy grail is Word compatibility, Microsoft Word compatibility, because like it or not, most legal scholars use Microsoft Word and most legal practitioners use Microsoft Word. I think there are a lot of difficulties with this just because that legal citation is so expressive. It doesn't really comport with Word's internal model of citation. But I think that that would be a really interesting problem to think about. And finally, I've been talking about this in terms of computer system, but I also think that this provides new avenues for thinking about how to teach legal citation. Because rather than just teaching legal citation as a bunch of weird rules about formatting and small caps, this is about teaching the system as a means of expression. And I feel like that's just a very different way of thinking about what the purpose of legal citation is. That really would be informative, even from somebody's very early stages in the legal profession. So I think that there are a lot of things potentially to be done and to be thought about here. This is just sort of my initial forays into this problem, and would love to hear your thoughts about this. Thanks, everybody. I really hope that everything is still connected.
Everything's
still connected?
Everything is still connected. We got that. I saw it all and heard it all. We have a few minutes.
That's great.
Yeah, we've got a few minutes for questions. let me then ask one. Just can you speak to the time that it takes to incorporate this into a large document? How much processing time does it add to the compilation of a big file?
I would not consider it significant for articles, and that is largely because it can process an article linearly. Um, it actually takes longer for briefs because of the fact that it has to do the sorting of the table of authorities. But I would say that it's pretty minimal. It's on the order of the amount of time it would take to compile a couple of moderately complex text drawings or something like that.
What was the most challenging thing to wrap your head around in terms of translating the citation problems into something you could actually code up?
That's a good question. There have been there have been a lot. There have been a lot of those. I think probably the most interesting one. So I mentioned the fact that you can have a reference that's inside another reference. So this is pretty common. If you're citing a chapter, you're citing a chapter that's within a book, but things are not as consistent as that. There's one example of what's essentially a law review article that is published inside a reporter of cases. So, you have a bunch of cases, and then there's just one law review article sitting in there. And finding a good way of citing that was fairly difficult. So, one of the things that I had to develop for the system was a generalized concept of document containing document, not the contained document, and figuring out how the programming for that works, and also some of the semantics of that, ended up being a somewhat interesting challenge.
Anyone? Yes, good. I don't want to hog this.
Just one question about the language. Is it possible that language has some kind of recursion where you might go through the loop? And is it, or it's usually just you can unroll and it's just number of iteration, like bounded iteration? I'm just trying to see if it is corresponding to Turing complete or not.
So, theoretically, you could create a loop of references. If so, basically possible in terms of actual things you would want to cite. But remember, so I just mentioned that you could have a container of citations. You could end up with a situation in which you declare that a thing was inside itself, essentially, and then you would potentially have a loop. I don't like my sort of intuition is to say that you probably would. So number one, you would not want to do that, and have conditionals within this that I can think of. So I don't think you would end up with a Turing complete system through the citation language, but that would be actually sort of an interesting question to think about. Yeah, I think that there could be you could ask some interesting questions if you were to analyze the sort of structure of embedded citations and such. I'm not sure whether or not that would come up.
computationally, how hard do you think it would be to reverse the process and generate out the references from the citations as they appeared in an actual article?
So to take a formatted article and to go backwards?
Yes.
There are a couple of research projects on that. So that is actually a fairly commercially valuable thing to do, to be able to essentially parse citations. And imagine that in parsing citations, the people who are designing these parsers have to create some sort of internal data structure to represent the references that they're identifying. The reason this is commercially valuable is because this allows for sort of empirical analysis or data analysis of case law, and that turns out to be something that a lot of lawyers want. Generally, for those projects, though, I don't think their concern has been really untangling the structure of the citations. It's mostly enough for them to just identify something is a citation to this reference, and I know that it is this reference, and that provides me with information, and possibly you know what signal they used before it. So at least from the research that I've seen, most of the work in going in that direction, going from formatted citations to some sort of higher level data structure, has been about sort of trying to identify document types, or to identify semantic content out of an individual citation, rather than trying to piece together the sort of structure of how several citations within a citation string or within a document interrelate.
Great. Thank you. Let's have a round for Charles.
All right, thanks everybody.
And we are going to move on to our fostering collaboration exercise. So just give me a moment to put up the slide for this. Designed and created by Emma, so the example is hers, but we're going to spend about 5 minutes jotting down or thinking about kinds of collaborations that we're looking for. So that will involve putting down, first of all, what you can bring to collaboration, the areas in your home discipline that you know well and can contribute to. This can be legal areas or technical areas. They can also be higher level skills, the ability to translate legal representations into something else, or the ability to design languages. And similarly, what are we looking to get out of a collaboration? What kinds of goals are there? Is it producing systems that do something? Is it somebody bringing in expertise in a domain that you need to catalyze work? Is it pursuing grants? Is it building systems that do something in the real world? Like, what do you want others to bring to the collaboration that will lead to successful outputs? And then, what areas outside of your own area are of great interest to you? So, like, I've been, for myself, it would be programming language design, that I'm interested in the language primitives that map onto legal ideas. So that's where I've pursued collaborations in this space, but everybody here brings something else in. So we'll spend about 5 minutes thinking about these. And so here's Emma's example for what she does. She has experience in building systems, in the methodology, and in formalizing things, perhaps based on data analysis. She would like to get out more expertise in policy and a better understanding of where the pain points are for mechanizing or formalizing law? What are the places that law is resistant to the kind of formalization that PL does? And she's interested in legal domains that include privacy, extranational policy, I'm thinking that probably means international or policy that goes beyond one country, and the challenges of law as related to science. So we'll take about 5 minutes doing that, and then here's her example, and then we'll spend the rest of the time doing like speed dating. We'll do sessions where we talk to somebody else and exchange our ideas and see whether there's a fit for collaborations and also just learn more about each other. So let's do 5 minutes starting now, and then I'll signal when we can do the conversations. it's time for our first speed dating session. So you have 7 minutes to talk to your first partner, pair up, find somebody who is not from your discipline ideally, and we'll see you in 7 minutes. Emma, can you hear us? You're muted. Can you try talking?
Yes, can you hear me?
Yes, we can.
Hello?
Great. Can you hear us?
Hello?
Can you hear us? Hello? Can you hear us, Emma?
Okay, that was a significant delay between when I asked that question and when I actually heard it.
Okay. Emma, would you like to give the closing remarks? Okay. Emma, would you like to give closing remarks? And we'll just wait for you so we don't run into the delay. We see you but don't hear you.
Hello?
Hi, Emma, can you hear us? We had to switch microphones.
Okay, so I'm not going to get any feedback from anyone in the room because there is, I think, no sound coming in. So if people have any questions, flag James, who will type it into the chat. So, great. So this is going to be very brief. So people can get back to having excellent conversations that I'm really sad to have missed out on. Yeah, so to start with, so this section is the future of ProLaLa. We're going to basically have 4 slides. We're going to go through some acknowledgements, discuss the past of ProLaLa, the present, and the future. So we're going to start with the thank yous because I'm not there. I can't really react to people, but if there is anyone from the program committee currently present, please give them a round of applause. I'm going to awkwardly wait for like 10 seconds. Okay, that probably wasn't 10 seconds, but moving on. And if there's our student volunteers are there, please give them a round of applause. And I'm really glad that you can't see my video because this is extremely awkward. Thanks to all the speakers, the authors, the Splash organizers, and everyone else who made this event possible. Especially, you know, the volunteers who made it possible for me and others to be able to participate remotely. This has been great. So, real quick, for those of you who maybe aren't aware, this is the 3rd iteration of ProLaLa. And the last 2 were held with Popple, which is a very different conference from Uppsala, which is still in the programming languages, you know, sort of community. And so those 2 were hybrid. This one's not I guess maybe not entirely hybrid. And in the first two, we had a lot of submissions, especially in the first one, from folks who were very established in, automated legal reasoning and symbolic reasoning and classical AI, those sorts of approaches to law. And then last year, there were a lot of papers. That really leveraged constraint satisfaction, apply them to things like regulations. And we saw quite a few papers that used answer set programming. It was really having a moment last year. This year, there weren't quite as many techniques that were prevalent, but the topics were broadly, we saw like tax law and LLMs, and we had this talk on privacy. So we had a little bit of consistency in those topics. And that leads us to the present of ProLaLa. And one of the things I wanted to highlight were two big differences from prior years. So the first was that the structure of this session and the goals were a bit different. And so in the past, we had mini conferences, and mini conferences in computing, for those of you who aren't in computing, these are equivalent, the conference publications are equivalent to journal publications. Oh, apparently you can't see the slides changing. Interesting. Maybe if I share and unshare.
Hello.
Okay, I'm going to not put this in presenter mode and just do this kind of the old-fashioned way. Um, so, can folks hear me? Can I get a confirmation that you can hear and see the slide that says present of ProLaLa? Great, thank you. Um, so, as I was saying, this year, one of the big differences we had was in the structure of the conference. So typically in computer science, we publish in conferences. What we call conferences produce the equivalent in other fields of journal publications. Now, a lot of our conferences actually do produce journal publications. We have a more journal-like review process, but they're very formal and serious. I mean, they don't have to be serious, but they're very formal nonetheless. And this year we wanted to go for a little bit more of a workshop feel rather than a mini conference feel. And one thing that the co-chairs we all discussed was this idea of really trying to use this as an opportunity to focus on misconceptions and bridging divides. And so I hope that we were able to do that. Please give us feedback. You'll have the opportunity to fill out a survey at the end of this. But the other big difference we had this year were some challenges in recruiting and advertising. And so we would definitely like to hear back from you about this. The first was we were concerned that we maybe had trouble reaching people because we think, or when we think some of the reasons were things like potential fragmentation in the information ecosystems we're part of now. Not everybody's on Twitter anymore. A lot of people are on Mastodon, and you don't always get the same information flow because it's not as centralized. People are like a lot of mailing lists have changed. A lot of people have moved institutions in the past couple of years who have participated in these programs. And so it's been kind of difficult to keep track of who all is interested and get the word out. The other thing is that the timeline for submissions has changed from past years because of the move from Popple to Uppsala. And so it, excuse me, it fell during a end of semester break, and that may have contributed to, a lack of dissemination throughout the community. The other question we had was whether or not we have reached a point of saturation amongst those who are working at this specific intersection. And this could be the case because it is a relatively small community. The PL community within computing is not particularly large, and so having a PL plus law group, especially in relation to data-driven legal informatics, could mean that we're just a much smaller group. And it could also be possible that we're perhaps too disparate across law. So even if you have a consistent group of people who are in PL who are interested in legal applications, appealing to people who have expertise, specific legal specialties, might be a little bit difficult to get that word out. And so those are some thoughts we had and would love to hear back from you regarding some of this. This year, one of the things we wanted to highlight was this new type of submission activity, so submission type, which is structured activities. So there's a lot of excitement when we were sort of chatting with folks in the ProLaLa community about this. The bad news is that we only had one submission of this type, and there wasn't anything outside of the call for participation prompts. But the good news was that prompting works. So if you put some ideas out there to get people start talking, they're like, "Hey, I actually have something to say on this." And so we really want to take this as a launch pad in today's social activities to try to get all of you to think about what would help benefit will help inspire your a future submission for ProLaLa 2025 of this type. So we think there's still a lot of possibility there. Again, we'd love to hear from you about that. And speaking of ProLaLa 2025, it will be held again at UPSLA in Singapore. And so the topics, it's up to you. Please submit or consider submitting. We are seeking 2 new co-chairs, preferably one of each from law and policy or programming languages, software engineering, or formal methods. The idea is to have 2-year overlapping terms. So James and I will be staying on to help guide and help the new chairs. But the way that this process works is 2 new people would come on and we would sort of hand off to them for a bit. We've also been discussing some suggestions for what to do with this particular conference moving forward. And so one idea is to start working a little bit more closely with CRCL and having things like invited talks from already published articles, or having unpublished presentations on partial work to get some feedback and provide a pathway to journal publication. I would also encourage folks, for example, at dinner tonight to discuss possibilities of other activities like hosting a dog stool or creating a new mailing list or even something like a blog, or I don't know if people do vlogs anymore, podcasts, not postcast, podcasts, that sort of thing. Is there something that would benefit the community that would give a platform for people to have the kinds of conversations that we're hoping to have? So let us know what you think. There's this Google form that's open. The QR code there should lead you to it. There shouldn't be any kind of blockades on that. If there are, if you have any issues accessing it, please message me directly or post in. I guess there's not a dedicated session in the section in the ProLaLa channel Q&A. But I think you can actually apparently you can create a post as long as you have both a topic and content. So I will turn it to the room. Are there any outstanding questions?
Hello, Emma, can you hear us?
Okay, right. For planning ahead for 2025, I want to point out that UPSLA and ICFP are co-located next year, and they're happening in the same week. So I think this is a great opportunity. You could double the number of attendees, but it also raises some constraints. So you might want to reach out to the organizers of similar workshops or events and see if you can combine ProLaLa with something else. Because whatever it is, it's likely to overlap with UPSLA main track or ICFP main track. But again, it's going to be a very exciting event, UPSLA and ICFP.
Thank you. Good point. Other questions? Yeah.
Okay. One question about with regard to publication. The plan is to still keep it informal, like, or we have proceedings for the publication from the submissions or accepted paper.
I don't know if we have a definite plan. We're open to community feedback on what is most helpful for building the field. Sorry, just typing this in for Emma. Okay, it is. I don't know.
Can you hear us, Emma?
I think we have reached our natural closing point. Thank you all for a very interesting day.